Lordship,
Yes.
may I make a mention as regards item number 18? We have received positive instruction in favor of the petitioner, my lord. Let it be on record in the form of affidavit. Lordship, may kindly have a look.
No. What is the instruction?
Subsistence allowance or instruction. Lordship,
To the proceedings.
yes, government servant
proceeding
a suspension under FR 52. They have said, my lord, I have not gone through the provision.
Suspended was in 2014.
Yeah, thereafter he expired.
Ah.
So they have
Now to everything gone.
Yes.
Now you are processing the matter
yes.
for pension.
Lordship, may I read? On the strength of the above FRSR rule, the suspension period on with effect from 1/3/14 to till his date on 1/4/2024 of late Hare Krishna Sarkar, expired head teacher so and so is ever regularized posthumously for all pension benefits to his legal heir. It may be stated proposal for area salary has already been submitted to your good office by it is from Deputy Inspector of Schools to Director of Education BTC. And regarding subsistence allowance, they have
Ms. B. Bhuya, Learned Counsel.
Lordship, may I?
Learned Senior Counsel and Standing Counsel BTC. On instruction submits that the matter is being processed for authorization to the petitioner, pension and pensionary benefits. Submits that the period of suspension of the husband of the petitioner has already been regularized and proposal submitted for withdrawal of arrears salaries. So in view of the above, she prays that the matter be taken up after 3 weeks, or by which time she would file an affidavit bringing on record the updated position with regard to the consideration made in respect of the pension proposal of the required pension proposal mandated to be so processed in respect of the petitioner here. Prayer accepted. Registry to list this matter after 3 weeks on a date to be fixed by.
Lordship, may I pay for a date?
Date 6/4.
Maybe
Before
before 31st.
Before 31st. 30.
Obliged.
Obliged. 30 going to. Yes.
Matter pertains to area salary. Kindly tomorrow, my lord. Please.
Area salary, no urgency. Yeah, where from when?
My lord.
Area salary from when?
Area salary in the month of 2023, my lord.
23. Survive for another week.
My lord, out of 5 petitioners, 3 have been released, and I am remain. So my lord, this
You
case
get
is
it. Pukrubar. Friday.
May I please,
Yes.
Lordship?
All mentioned matters, don't need to mention, give it to. Give
Lord,
it.
additional affidavit started file, my lord. Maybe
Call it. Call.
obliged.
Lordship, item
30.
30, Lordship.
Mr. BP Bora, 30. Learned Counsel for the petitioner submits that he be granted 2 weeks time, 3 weeks time
Yes, please.
for 3 weeks time. Praise that the matter be adjourned for 3 weeks on account of what is the ground?
Lordship, I wanted only for 1 week because I'll be not available
Okay.
in the second half.
Praise that the matter be taken up after a week, inasmuch as he has certain personal inconvenience actually. Was a prayer accepted? Registry to list this matter after a week on a date to be fixed by. Yes.
Deeply lovely.
May I please, Lordship? Item number 5, Lordship. Perhaps, Lordship, P. Bhattacharya is handling this matter.
Item number 5. Registry to list this matter before any other bench without.
Obliged.
May I please, Lordship, with the consent of other parties, I beg to mention item number 20 and 21, my lord.
A prayer is made on behalf of Mr. A.K. Burwa, Learned Counsel for the petitioner in WPC number 5954/2024 for an adjournment in the matter on account of personal inconvenience. The other one also you have taken consent?
My lord, already.
The prayer is also not objected to by Mr. D.K. Nath, Learned Counsel appearing for the petitioner in WPC number 4540/2023, as well as the Learned Counsel for the respondents in the above noted to writ petition accordingly. Registry to list this matter again after 2 weeks on a date to be fixed by.
May it please, Your Lordship, with the consent of the other side, I beg to mention item number 29. Lordship,
20?
29, Lordship. Lordship, the conducting counsel, Mr. S.P. Sharma, has some medical emergency today. Adjournment may be given, Lordship.
Have you taken the consent?
Yes, we have taken.
Prayer is made on behalf of Mr. S.P. Sharma, Learned Counsel for the respondent number 5, WPC Mariva. Oh. For an adjournment in the matter on the ground of personal inconvenience. Prayer is not objected to by the learned counsel for the petitioner.
Yes, Your Lordship. Applicant petition.
Prayer is not objected to by the learned counsel for Mr. Adas caring for the petitioner. So in view of the above, registry to list this matter in after 2 weeks on a date to be fixed.
So interim orders may be continued.
Interim
Both
orders.
the IS and the writ petition, Your Lordship.
Interim orders passed in the writ petition as well as the interlocutory application shall continue till the next date of.
Much obliged. May please, Lordship, with respect to item number 19.
Acclaimed.
Lordship, with respect to item number 19. I am filing affidavit because Lordship, the special messenger is coming, the train is delayed by 2 hours. Lordship, may taken on witness Thursday, Lordship.
No. Sorry,
Lordship,
we directed you to file it today. We want it today.
yes, Lordship.
And he undertook, not me. He undertook.
No, no, Lordship, yes, he is sent the special messenger, but train is.
We are not, we want the affidavit in the records today.
Lordship, but.
Otherwise, it will be a cost on you, I'm telling you, because that was an undertaking given by your registrar.
Yes, Lordship, correct. Lordship, he is already sent.
We'll wait till the last item.
Yes, Lord.
May I please, Your Lordship? So I beg to mention item number 35, my lord.
30,
35, my lord. I'm paying for adjournment for the day. My lord.
why?
Due to some personal difficulties, my lord, we're unable to take the passion.
You are Mr. A.K. Azhar.
Take care, sir.
The prayer of Mr. A.K. Azhar,
After 2
learned
weeks.
counsel for the petitioner, matter stands adjourned for 4 weeks. Registry to list this matter after 4 weeks on a date to be fixed.
I'm seeking, my lord, 2 weeks.
Daily, why this matter should, if you're not doing it, don't do it.
Wait, Your Lordship.
Here in this case, the petitioner made an application for furnishing him.
Where is the order modifying the penalty?
Lordship,
Lordship, the learned counsel is on Lex. Can this
Who?
matter? D. Upamanya, Mr. D. Upamanya. Mr. D. Upamanya.
Okay, Mr. Sharma, you find it out, but
Yes,
let that Mr. Romani also.
So in this case, instruction was sought for. Proceeding Gauhati this.
Why there is no standing counsel for the elementary, secondary education? Where is it? We can't wait like this for every matter. So Sharma, yesterday also,
Lordship may issue a notice that.
let us see, let him come. None appears for the petitioners on call. At what? Beleg matter. Yes, Mr. Kaur, what is your matter?
At first glance, it looks very simple, but as we go into it, I think, well, your
one?
lot has to examine it.
Mr. Kaur,
Yes, madam.
let us see the simple first. There were 4 persons recommended.
Yes.
2 were
Underqualified.
2 were recommended and 2 were provincialized.
Yes.
2 were not.
Because they were underqualified on the date of provincialization, under the old act of 2011.
So under the old act of 2011, how many posts are given to a college?
At that point of time, it was only 3 posts were eligible. So
You were the fourth man,
in terms of seniority, I am the 4th man. But in terms of
qualification,
qualification,
you are the second.
Second.
Now, after they sought to terminate you,
Yes, ma'am.
you are being terminated because you are the 4th man.
Oh, yes,
You are being terminated, you are the 4th man.
yes.
Have they also initiated a process to bring in the other 2?
Yes, in the meantime, what has happened, after I got the stay I give the dates, madam.
Hmm.
After I got the stay, the other 2 persons in the year 2021
Under the 2017 Act.
rules, they have been provincialized. As on date, madam, nobody will be affected
No,
because
no.
they
As on date, are they provincialized as teachers or as
assistant professors.
as
Teachers, sorry, teachers.
you are appearing for them?
Yes, for the college.
for the College of Justice. You have got nothing to say.
No, my lord, that 2021 provincial.
No, that is different. They are not here. They have not challenged that also. They have not challenged that. Those two teachers have not challenged it. Yes, Mr. Das.
Lord,
He is fourth.
yes,
Admitted.
that is
But
admitted.
when the recommendation finally came, he was number 2. And you have 3 posts. If we look it at that angle because of the delay now, 14. Oh, why keep him hanging?
That recommendation was wrong, my lord. Because the
Recommendation was wrong. How?
recommendation is the second candidate, my lord.
He should have been the 4th candidate.
Yes, my
But
lord.
the 2 were unqualified,
Yes,
underqualified. So the
my lord, if my lord kindly sees,
understand they should have been brought in.
yes, my lord.
They
As
ought
as
to
per
have
the
been
act, my
brought
lord,
in
if
by giving them that 5-year period
Yes,
for provincialization.
that was not challenged.
If those 2 people had come in, then Mr. Kumar would have been out.
Yes.
yes, yes,
But they were not brought in
yes.
and they have not even expressed any grievance. So why should we? We'll give it a quietus now.
Then at this stage, my lord, now if the case of the petitioner has to be considered,
No,
It has to be
It's already
considered recommended.
recommended, following the rules.
Then you have tried to withdraw it. That was stayed by this court. That is a stay order.
Yes. And subsequently, the other 2 were provincialized under the
21.
2000 Act
And
on-
they have not raised any grievance.
Yes.
Mr. Hazarika,
for the college.
what do you call it?
my lord, my submission will be, my lord, what I have understood, my lord, for going through this case, my lord, that as per the act, my lord, proviso of 4(2) of the
Hmm.
2011 Act,
Hmm.
it says if the number of employee working in a venture,
Oh,
Yeah,
that is the
they-
problem, Mr. Sudas. That is the problem.
yes, my lord,
Those 2 ought to have come in. Those 2 were to be provincialized.
yes,
By giving them
No
those
doubt
time.
about it.
Yes.
yes, yes,
No doubt about it.
yes,
But somebody thought something, or Mr. Kumar's influence that he has, his client got provincialized.
Yes,
Others 2 were dropped.
yes, my lord.
They have not challenged that.
They have
He
not
was
challenged-
provincialized. Then what happened is that provincialization, if we use the word deprovincialized,
Yes.
Deemed.
he comes up before this court in 2014. In 2014, this court stays that 11 years down the lane, those 2 have not come up with a plea that we also have to be considered as of 2011. They were given under 2017. Again, influence of Mr. Kaur. They are afraid to come before this court. Now, what should this court do?
And as on date, my lord, the college requires 5 teachers. There are 4 teachers. That is
They are
also
losing out. They are losing out. You are getting it from
Yeah.
UGC scale from 2014.
yes.
They are getting it after 7 years.
Still, my lord, out of context. If they had come for seniority also, then it was also a different case. They could have got
They
it
could
from
have
there.
got it. They would have
But,
come in.
but they have slept over their rights. So that's the
Because the 2011 Act, there is no concept of tutor.
yes,
Yes, ma'am.
yes.
It is
No one, sir.
appointment, but with the stipulation that you will have to get that qualification
within 5 years.
within 5 years.
Yes, ma'am. My lord, that has to be considered in a fresh manner, my lord. Because, my lord, as per the act, my lord, if the number exceed, then the seniority will come, my lord. The petitioner's service was my lord, provincialized wrongly, my lord.
I would have
That's-
understood that if the others were here. And today,
Ma'am,
after 11
my
years, we are
humble
not going
observation
to
would be
disturb this. question.
Others coming or not coming will not affect this provincialization, my lord, the list
Have you
of.
filed an affidavit here?
Yes, yes.
Yes.
What is your stance? Sir?
Our stand is, my lord, same thing, my lord, the 4th post. Para 6 of our affidavit. my lord. Para 6 onwards.
This running.
Naturally, he was 4th. There is no dispute.
Yes, yes.
Concurrence for major would have brought it to 4 posts.
Yes.
Then he would have come in. There was no concurrence for major.
For measure.
Ah.
Yes.
So, why have you not urged here in this writ petition that the petitioner is to be removed and the other two has to come in? You have not said that.
Because they were not eligible, my lord.
Now the stand of yours is
Yes.
qua the petitioner only. You have not brought the other two underqualified candidates into the picture. If your stand was, in his place, the other two has to be brought in, we would have understood. Yeah, that is not even a plea here.
My lord, that is-
After 11 years, being too liberal, but can't help it in this fact situation.
What
Lekha,
what
huh?
I understood, my lord, to the act, my lord, that if the number, my lord, number of post, number of incumbent exceed 4 posts,
Okay,
then
show
the
me that,
qualification will
show me
come, my
from
lord.
your affidavit that two persons otherwise who were eligible were not brought in, so we had to interfere. Where is your stand? Just show me one line.
That stand is not there, my
Then, if you don't file that, take that stand, how can we?
and this stage, my lord, this 11 act is not there.
No, no, that Supreme Court has clarified now.
Need not be, because if we interfere with the order of deprovincialization, the order of provincialization automatically gets revived. And it is already under stay. After 11 years, nearly 12 years now, why should we? Lekha, heard Mr. B.D. Kaur, Learned Senior Counsel, assisted by B. Dole, Learned Counsel for the petition. Also heard Mr. S. Das, Learned Standing Counsel,
I'll be paying,
Secondary Higher Education Department,
I'll be paying for 1
appearing
and
for
2.
the respond number 1 and 2, and Mr. P. Hajorika, Learned Counsel, appearing for the respond number 3 and 4. The petitioner in the present writ petition has presented a challenge to an order dated 5/11/2014, issued by the Director of Higher Education, Assam, by which the provincialization of the petitioner effected while an order dated 21/2024 was withdrawn on the grounds that the petitioner was the holder of the 4th post in the English department and the college did not have government concurrence for major course. As projected in the writ petition, the petitioner was recruited as a assistant professor in the English department of Laluk College in pursuance to a process of selection. The appointment of the petitioner was effected while an order dated 8/10/2010 and the petitioner joined his services on 9/10/2010. So, at the time of joining of the petitioners, there were already 3 other assistant professors working in the department recruited before the recruitment of the petitioner herein. So, the college at the time of recruitment of the petitioner was in its venture stage. Also, the government thereafter enacted the Assam Venture Educational Institutions bracket Provincialization of Services Act 2011. Also, the college of the petitioner being found to be an eligible institution for having the services of the teachers and staff working therein for provincialization, comma, the case of the eligible teachers in the said school college was taken up for consideration for provincialization of their services. The constituted committees on considering the eligibility of the lecturers, including the assistant professors, lecturers working in the English department, proceeded to recommend the names of all the 4 incumbents working in the said department as lecturers. Also, on conclusion of the said process, comma, a list of eligible professors of the assistant professors of the college, a list of professors of the college found eligible to have their services provincialized came to be published. Also, therein, one Bishop Jyoti Borpatra and the petitioners herein were reflected to be qualified candidates for provincialization of their services against the post now required to be sanctioned to the English department of the said college. Also, in consequent to the declaration of eligibility of the petitioner herein, comma, the petitioner was wide order dated 21/2014, provincialized was wide so and so, provincialized in his services with retrospective effect, that is with effect from 1/1/2013. The petitioner accepted the said provincialization effected in his case and joined his services in such capacity as an assistant professor in the Department of English. It is at this stage, the full stop. Thereafter, wide an order dated 5/11/2014, reckoning that the petitioner was the holder of the fourth post in the English department of the college, comma, and the college not having a government concurrence for major course, comma, the Director of Higher Education Assam proceeded wide order dated 5/11/2014 to withdraw the provincialization as affected in the respect of the petitioner herein, wide the order dated 21/2014. Subpara, being aggrieved, the petitioner has instituted the present writ petition. Mr. B.D. Kaur, learned senior counsel, appearing for the petitioner by reiterating the facts noticed herein above, has submitted that although the petitioner was the fourth holder of the post in question, comma, the constituted committees under the Act of 2011, having found him and one Bishojit Borpatra to be the only qualified candidates possessing the requisite UGC norms for provincialization of their services, comma, the petitioner was provincialized in his services by construing him to be the second assistant professor in the school, in the college, in the Department of English. Mr. Kaur submits that in terms of the provisions of the Act of 2011, comma, 3 posts are mandated to be so sanctioned to a particular department of the college for provincialization of the services of the teachers working, of the professors, assistant professors working therein. And accordingly, he submits that the petitioner being so found qualified for recruitment, for provincialization of his services, comma, his services were so provincialized against one of the 3 posts so sanctioned to the English department of the college in question. Also, Mr. Kaur has submitted that the petitioner admittedly was the 4th post holder, and there were 3 others above him in the department, and in the usual course, it ought to have been that the first 3 in the usual course, the services of the first 3 incumbents ought to have been provincialized. However, the constituted committees having found the petitioner and said Bishojit Borpatra only to be qualified in terms of the UGC norms holding the field, comma, recommendations came to be made in their favor. He submits that the 2 other candidates in the fray who were senior to the petitioner had not raised any objection with regard to the provincialization effected in respect of the petitioner hearing. He further submits that the two other professors who senior to the petitioner working in the English department of the said college were considered for provincialization of their services in terms of the provisions of the Assam 2017 Pura Likhini Bhai Act, and their services were provincialized by issuance of an order dated 5/2/2021, right?
Yes.
5/2/2021. So, the said two professors have also not presented any challenge to their such prospective provincialization of their services. In view of the above, Mr. Kaur submits that the order dated 5/11/2014 would mandate an interference from this court. Mr. S. Das, learned senior counsel, learned standing counsel, Higher Education Department, submits that in terms of the provisions of the rules of the Act of 2011, more particularly the provisions of subsection 2 of section 4 of the said Act, the proviso to subsection 2 of section 4 of the said Act, where the number of such employees serving in a venture educational institution exceeds the number as specified in the schedule, the provincialization of services of the employees shall be on the basis of seniority in a respective category in the concerned educational institution. He submits that in the facts of the case on hand, the category as finding mention in the proviso to subsection 2 of section 4 would be the English department, would be the post of assistant professor in the English department. He submits that in terms of the schedule to the said Act, 3 posts of assistant lecturer was stop lecturer assistant professor. Assistant professor was to be sanctioned for each department for the past course, and in the event the concurrence was received by the department concerned for also offering a major course in the subject concerned, one further post was permissible to be so sanctioned. Mr. Das submits that in the case on hand, submits that with regard to the English department of Laluk College, the said department not being granted the concurrence for offering a major course, the said department was only offering a pass course, and accordingly, only 3 posts were mandated to be sanctioned to the said department. Also, accordingly, he submits that there being 4 incumbents working as assistant professors in the said department, the provincialization of services against the 3 posts now sanctioned ought to have been made by reckoning the services rendered by the first 3 senior incumbents. He submits that the petitioner, being the 4th incumbent in the department against the post of assistant professor, was not entitled to have his services provincialized under the provisions of the 2011 Act. Next, Mr. Das submits that on account of error committed in processing of the case of the petitioner, his services came to be provincialized by an order dated 21/2014. Also, he submits that although the services of the petitioner was provincialized by the order dated 21/2014, the said order also incorporated within itself a condition to the effect that in the event if any defect is found and or procedural lapse is found to have occasioned in provincializing the services of the incumbent concerned, the same would be mandated to be cancelled without any prior notice. Mr. Das submits that on the fact that the petitioner was not entitled to have his services provincialized against the 3 posts mandated to be now sanctioned to the English department of the college in question, the respondent authorities, more particularly the Director of Higher Education Assam, proceeded while order dated 5/11/2014 to withdraw the provincialization of the services of the petitioner as affected while the order dated 21/2014. So, in the above context, Mr. Das submits that there is no error committed by the respondent authorities in issuing the order dated 5/11/2014 and the same having been so issued to rectify an irregularity committed in the matter, the same would not mandate an interference. Mr. P. Hajorika, Learned Counsel, appearing for the respondent number 3 and 4, submits that you have only that submission, nothing else.
Well, that his appointment was on the fourth post is the major subject. We have forwarded the
Name, everybody's name.
showing him as the fourth.
Mr. P. Hajorika, Learned Counsel, appearing for the respondent number 3 and 4, no? 3 and 4 submits that the college authorities had forwarded the name of the petitioner by reflecting that he is the holder of the 4th post. He submits that the consideration in respect of the petitioner by the respondent authorities was so made by construing him to be the incumbent in the 4th post. He submits that it is not known as to the reason existing as to why the services of only the petitioner and said Vishwajit Borpatra came to be provincialized by the respondent authorities. Also, he submits that the other two incumbents placed in seniority position between Vishwajit Borpatra and the petitioner herein, however, had not assailed the provincialization of the services of the petitioner, nor approached any authority and or this forum, this court.
That instruction.
Have they filed a case here?
That instruction.
Correct. Mr. Hajorika has further submitted that the two other incumbents placed in seniority position in the Department of English between Vishwajit Borpatra and the petitioner hearing, the services of the two other were considered by the respondent authorities under the provisions of the Act of 2017, and the said incumbents were so provincialized in and the services of the said incumbents were provincialized by an order dated 21/2014. He submits that the said two incumbents have accepted the 5/2/21 by order dated by have accepted their provincialization of services as affected while the order dated 5/2/2021 and are continuing in their services under the said order of provincialization. Also, I've heard the Learned Counsel for the petitioners, Learned Counsel for the parties, and peruse the material. Disposed of. We are allowing.
We are deeply obliged, Your Worship.
Anything left out? Nothing?
No, that's. I was only under the impression that earlier, since the 2011 Act was unconstitutional, so whether I could get. But now a recent judgment of the Supreme Court in case of music
No,
teacher
we
has
are not
clarified.
going to that. We won't go into that
Yes.
because this is Quadi 2011.
Yes,
If we don't interfere with the order,
yes.
then a issue would come whether you can be considered. Then you will have to be considered under the
7 days.
new act.
But Supreme Court has said that if I was eligible under the 2011 Act, then you can be considered.
You will have to read it in
Ah,
between the lines.
ah.
You will
No,
have
I
to
think
read
there's
it.
much time.
You will have to read it in the context of that case
Yes,
and the provisions of section 10(4).
yes, yes. Because one word I have seen makes lot of difference in this act. I did not have much time to read in the morning, but whatever I had read. I'm obliged.
You did not read, you only have to smell.
Obliged, Your Lord.
Only.
My lord, in item 2, I'm seeking a passover, my lord. Mr. K. Gogoi is held up in another court.
Hmm?
He'll argue.
Yes, Mr. Bhuya, what is your grievance?
My lord, my grievance is that, my lord, I was working as a principal and my cutoff date of appointment was beyond that, my lord, 31/12/2010. Now, my lord, my
Now
proper,
you say that
my lord,
the others have been regularized,
provincialized, my lord,
huh?
provincialized.
Provincialized as principal and you are tutor
I have
principal.
been only person, no, I have even not been provincialized as a tutor, not under the 11 Act, not under the 17 Act, till date I am jobless, my lord. That is the issue, my lord.
Okay.
My lord, can it be taken up on, my lord, Thursday, my lord?
Today.
No, my lord, that one judgment of the Honorable Apex Court, my lord, which I should not bring today. It will
Okay,
have
we are aware of that judgment. You can
That-
make your submissions.
that music teacher case, my lord.
Nur Islam. I had the opportunity to appear for him when I was stuck.
No, I know, my lord, I know,
So I know the facts. You can just rely on that.
my lord. Today, my lord,
Today, whenever convenient.
much obliged.
Mr. Monto, what are you waiting for? Yes.
That better.
Yes, Mr. Das. Who is appearing for the SSA? Mr. Gogoi is coming. Okay.
My lord, here also, my lord, Mr. K. Gogoi will argue, my lord, if, my lord, my learned senior friend,
No, this
sir
is
can argue, my lord.
school. This is school.
No. This is here. Top of the list, huh? Top of the list matter. It will motion to.
SSA.
Item number 6.
No. Motion, not motion. The 37, motion.
Oh, I see.
Oh, you have something else? We can do that. No problem.
Well, that top of the list matter.
We'll do that.
Yeah.
6, yes.
Item?
6 also, Mr.
Yes,
Gogoi will
yes,
appear.
my lord.
We'll take it up.
Senior sir can argue, my lord.
We'll not do. We'll hear it together. CMJ. Whether CMJ and ISC, that guideship can be holding the field.
That's the only point that was thrust out on the last occasion.
Hey, you want to do the motion?
Yes.
Mr. Gogoi is coming. Can you
Yeah,
wait
yeah.
for some time? Let Mr. Gogoi come.
Last time also, because he was not. on this board.
Mr. Monto,
Well,
just wait. Mr. B. Gogoi is coming. So we'll
this
hear
matter
it
also.
together
in this matter.
in
also.
this matter also. That is what Mr. Chisti made up some. Yeah.
Yeah.
None appears for the petition on call. Mr. SMT Sisti, learned counsel for the petitioner is, for the respondent is present. Learned standing counsel, Department of School Education, appearing for the respondent. Number 1, 2, 3, 4, 4 up is present. There is no representation on behalf of the respondent number 5, 6, and 7. Also, it is seen that there was no representation on behalf of the petitioner on the last date of listing, that is on 17/11/2020.
20, yes.
So, in view of the above, this court is of the considered view that the petitioner has lost interest to pursue the matter, and accordingly, the writ petition stands dismissed.
And he's also not eligible, if his name is not been.
I know that, yes. Why do it in merit when if he wants, he'll come back?
Yes.
But this situation has become infructuous. He has.
He has
retired
also been
or-
accommodated, it's returned again.
Mr.
Yes, retired.
Are you want to withdraw it? If we don't permit you, what will you do?
Since the petitioner has retired from his service.
Retirement is okay, one thing, but you have suppressed the fact that you were at the same point of time, same selection.
Yes.
You were appointed in some other school.
Yes.
Yes, he was also appointed as a
But you have
principal.
not disclosed that in the writ petition.
Yes, also.
You have not disclosed that in the writ petition. Why?
I think that was
Appointed the regular principal of.
He was appointed, same selection process he was
Yes.
appointed.
yes.
And you made us go through carry this file from 2018 onwards.
Yes.
So, and that too from a teacher, this is not expected. Mr. M.U. Mandal, learned counsel for the petitioner. submits that in view of the fact that the petitioner at the relevant point of time was also appointed as a principal in JM Higher Secondary School, Mankachar, and has thereafter retired from his services on reaching the age of superannuation, the challenge in the present proceeding to the selection and appointment of the respondent number 6 as principal I.N.Academy High Secondary School, Bilasi Para, has been rendered infructuous. Also, prayer accordingly, he prays that the present writ petition be closed. Prayer is not objected to by the Learned Council, Mr. S.M.T. Sisti and Mr. You are appearing for?
Oh, 6.
And Mr. Konikot, Learned Council, appearing for the respondent number 6. So, in view of the above submissions made by the Learned Council for the petitioner, the present writ petition stands closed on having been rendered infructuous.
Obliged.
That you have not disclosed.
I think I have
No, you have not.
somehow.
If you had pressed it, then I would have done something. But now you have now withdrawing it, okay. 7, yes. Yes,
My lord,
you got a brief.
I have got
Although there was no locus, you got a brief. So you
I
should be
got a
thankful.
brief. That is the
You
only-
should be thankful to the petitioner.
Absolutely, absolutely, my lord. In fact,
Nothing is here. Locus.
material
This
instructions,
was only for Mr. D. Chakraborty. This
my
case was filed.
material instructions did not come in abundance from my client.
Oh.
But nonetheless, I
came.
ensure that I appeared, and even today I'm
None appears for the petitioner on call. Mr. D. Bachaji, Chakraborty, Learned. You are
five.
appearing for?
5.
For respond number, Learned Council for the respond number 5 is present. Also, as none has appeared for the petitioner even on the last date of listing, that is on 19/5/2025, this court is of the considered view that the petitioner not desirous to press the present writ petition any further. Accordingly, the present writ petition stands dismissed. You are there?
Lordship,
Okay. Yes, what is your locus?
Lordship, kindly see order dated 10/3, my lord.
Forget the orders.
No, my lord, it has been converted to quarant 2, my lord.
Where?
10/3, my lord.
No,
Where?
my lord, it has not been converted. There was a
10/3,
query and
2023.
I have filed an
No.
affidavit.
Where?
Order,
Which part?
10/3, my lord.
order dated 10/3. There was a query raised by this honorable court.
Last-
I have responded to this.
Last 2 paragraph, my lord.
10/3/2023. And I filed an affidavit.
Where is your prayer for co-warranto?
No such.
My lord, the honorable court, my lord.
Honorable court cannot give you. You will have to make a prayer. Final opinion on merit. Therefore, the question of maintainability as raised by the still kept open. You have not made. You will have to have taken advantage of this order and then incorporated that way. You have not done it.
Lordship, I may be given.
No, I'm sorry. We are not giving you. What is your case? Who are you?
Lordship,
You are not a
maybe
guardian
today, my
now.
lord, I missed my file, my
I'm
lord.
sorry. We are not. We are going to dismiss it on the ground of locus.
No, when, my lord, this honorable court, my lord,
This honorable
On
court
this-
has also,
on this point, my lord,
has
not the
also in
government-
paragraph 9 said
on
that
this,
it is only tentative.
no, on this point, my lord, the honorable court, my lord, directed the government to file affidavit.
Forget it.
Lordship,
2018 matter, this order is
Last,
of.
last 2
20
paragraph, my lord.
I'm sorry.
Last 2 paragraph, my lord. Paragraph 7 and 7, 8 and 9. 8, paragraph 8, my lord.
It is clarified that the observation made above is only a tentative view of the court and does not form a final opinion of the court on merit, and therefore the question of maintainability as raised by the learned counsel for the response number 5 is still open to be argued on the next day. And he has argued that. Now you reply.
Regarding paragraph 8, my lord.
Forget 8. 9 is qualifying. And this is final hearing. Everything is open to boom. Show me a law that without a prayer for quo warranto, I can pick it up. I'll immediately do that.
I may be given.
No time.
Did I miss my file, my lord?
Oh. Second file to detail. At 2 p.m.
Obliged.
This is not the forum to settle personal vendetta. Anything more, Mr.
Montosarulka.
Mr. Vishwas, have you got the
I have filed an additional affidavit. Mr. Sharma was here.
Yes, Sharma requested me to take.
okay, fine. What is the additional affidavit?
Because as per your lordship's direction, your lordship may come to page 69, your lordship. This is the annexure. E.
The additional affidavit is not on record.
I have brought it on just now. Requisition was made.
It may not have come.
Requisition
What is that?
I'll just place, if I may, because I had given this, they have rejected that. They are saying that it is not in the proper format. What, if your lordship may just, the last line was there where it said that if this honorable court, we reserve our right to claim interest if the honorable court permits interest.
Why do you, that was not the thing. Why do you make unnecessary
I don't know what
incorporations?
point they gave, and because of
That
that,
is
they
getting
said that
greedy.
it was.
That is getting greedy.
The last line, I did not advise them with regard to that, but that was there. But they rejected it. They are saying that if the court permits, he did not ask for thing if the court permits, but unconditional, it was given, your lordship.
There cannot be a condition incorporated in a no claim
Because
certificate.
another thing I have placed on record, your lordship, may kindly come, there is another, in this affidavit, there is a page, I think it will be, I don't have a copy, it is clause 52, I think. I have 51(2), para 4, it is the final payment I have extracted.
Page?
I think it would be
52.
quoted page 51(1). There is two things, 51(1) will be there on the top. Page
5.1.
sorry, no, not 5.1 is the security deposit.
51. Huh?
51, one is there
Three,
and another one is there. No, please. I'll just point out that particular thing because the final payment was
Okay.
paid.
What we do is we'll hear that whether you are entitled to interest or not. Then
Yes.
we will consider.
Only this page 63, your lordship may see. This was the clause I was referring to, 63.
Fine.
This is final payment and final payment was made to us. Why? Because in page 64, it is there specifically that I have given a no claim certificate. Already it is on record.
Okay, if that is the thing, we'll consider the matter
Yes, sir.
in its entirety, Mr. Sharma. We'll hear the matter in its usual course.
Everything is ready, my lord, because of this document which
He has.
Yeah, I have pointed out to my lord.
Mr. A. Bishwas, learned counsel for the petitioner, submits that in terms of the order dated 12/2/2026, the petitioner had submitted his no claim certificate before the railway authorities
But with a right.
on 2/3/2026. However, with a rider that, with a stipulation that the petitioner reserves a right to claim interest on the long-standing overdue if the honorable court permits the same. Mr. Biswas submits that in the present writ petition, the amounts due is also claimed along with interest. Accordingly, he submits that the said issue would have to be considered by this court in the matter. Also, in view of the above, Mr. Biswas further submits that in view of the said condition, the no claim certificate submitted by the petitioner was rejected by the railway authorities. The said position is affirmed by Mr. B. Sharma, learned counsel for the respondent, who submits that it is only because of the rider has put in the communication dated 2/3/2026 that the railway authorities had to reject the no claim
It's
certificate.
not considered it to be a no claim. certificate.
Unconditional.
In as much as a no claim certificate is mandated to be unconditional. Also, the above issue having arisen in the matter, the same would be required to be considered by this court. Accordingly, admit the writ petition for hearing. Registry to list, admit the no formal notice is required to be issued as all the respondents are represented. Also, registry to list this matter for hearing in its usual course. Also,
May I just wanted one aspect of the matter, my lord. To decide the issue which is raised now, the contract agreement would be required. They have not annexed it, my lord.
that in the time of hearing, we will see.
They have not annexed it, my lord.
We are not. It will bring. In its usual course. Yes.
My pleasure. Then pass over timing, my scenery is unlike my. Sometimes.
My lord, this again is a case which has caused serious hardship to all these petitioners. Question basically involves when the certificate of disability with certain degree of disability has been issued by the statutory authority, can the appointing authority sit over it and without issuing any order to the ingenuity of this particular certificates, just refuse to act upon it and then doubt the genuineness of these certificates and send them to further medical board? And medical board after medical board heard and their findings are all contradictory. Can such a course be allowed in the process of selection and appointment to the post of thesis or in any other post? I'll see how the things have developed here.
Mr. Sharma, we are taking it up. Please don't ask for an adjournment in the midst.
Lordship, here, in fact, on the last occasion, Mr. N. Khatonier had appeared, Lordship.
Then we'll hear, we are not going to keep it parted.
Lordship.
We'll proceed with the hearing.
Some other day, Lordship, some accommodation, Lordship, because today he's on lakes, Lordship.
Who?
Mr. Khatonier is on lakes in another.
No,
court.
today
Some-
every advocate of the respondent seems to be in legs.
Always on lips.
and,
Nobody said.
And I'm going to, it seems that people are taking it very lightly.
Otherwise, here
I'm seeing it from yesterday.
we have filed our affidavit also here.
So that he read that and we'll pass orders, then we'll hear Mr. Then no need for many argument from your side. Yes, Mr. Monta, you continue. We'll read your affidavit, pass orders then.
Exactly.
That is what you want. You have nothing to argue.
No, Lordship, that is why on the last.
You said you have filed your affidavit, that's enough. Thrown the affidavit to this
No,
court.
no, no.
Then?
I'm not submitting.
That's well, Lordship.
Well, since 2022, it was heard and again.
Mr. Monta, can you give me the seriatim? How it proceeded? Advertisement,
Yes.
selection. What is the stand of the respondents with regard to the,
They-
you have
they-
a certificate, you have a PWD certificate. Now, basing on that certificate, you were eligible for participating in a
We
particular selection.
participated, we were
You-
selected,
You
we
were
were in the
selected.
final select list.
Then,
There
once you have put in the final select list,
Yes,
before your appointment, they have subjected you to a further
medical board.
So whether they can subject to you a further medical board or not, that is the issue. Now, what is the stand of the respondents here
Respondents say,
on this issue?
they say, because some unanimous complaints were there, this and that, they doubted the genuineness of the certificates, that many people have taken recourse to obtaining such certificates by fraudulent means and all. So they had a requirement to sort out who are the genuine candidates having.
Was it prescribed in the advertisement itself?
No, nothing.
It was only after the recruitment process.
Exactly. After the selection, final list was published.
Any decision of the any decision governing the position that when a certificate is issued by a competent authority, the contents thereof cannot be questioned by another authority.
To that,
Lordship, may I interrupt, Lordship? Lordship,
Mr. Sharma has already said you have filed an affidavit.
no, Lordship.
We'll go through that.
To that effect, Lordship, there is an appeal pending, Lordship. Appeal number 37 of 2026, Lordship, wherein the same issue came up when the petitioner is having a certificate of
That's
medical.
the only issue
Yes,
here.
that is pending. That is fixed on 30th of April, Lordship, before the division bench of this honorable court, Lordship.
Who is appearing in the?
S.K. Roy, petitioner for the.
well,
and Lordship.
probably there is a difference as my instruction goes, because after our selection was
30th of April.
No, what is the case number?
37 of 2026.
WA
Order dated
37.
26 to
WA
2026
37
of 2026.
26.
Yes, Lordship. And the order is of 26 to 2026, if I'm not wrong.
And the single judge order is of?
Lordship, he
Single
has
judge
preferred
has,
dismissed
Dismissed
the
the
petition.
rejection.
And then, Lordship, he
Recognizing your power to
Yes.
have that verification.
yes, Lordship, because the state has the ultimate authority to select the base candidate for a particular
But
post.
Mr. Upamanyu, one factor, this is also troubling this court.
And there is a OM.
Once there is you're also for the health department.
Yes, Lordship. And there is an OM as well.
Once a authority,
Yes.
normally these are district authorities, joint directors and all. They assess a person
Yes, Lordship.
and find him to be 40%
Yes, Lordship.
disability, because that's the cutoff benchmark.
Yes, Lordship.
And they issue the certificate, 40 and above.
Yes, Lord.
Now I have found that they come for recruitment and then they are sent to Gauhati Medical College,
Or yes.
Gauhati Medical College or any other medical college, and then there is an assessment done. In that assessment, it is found to be 18%, 20%,
Yes.
10%. So, see, parameters are the same.
Yes.
The assessment parameters cannot be different. There is a certain SOP there available that the deaf and dumb person comes, they'll subject him to A, B, C, D, F test, orthopedically handicapped, A, B, C, D, E, F, G, H test, and then come to a conclusion. Why this wide variation comes in? That means
Lordship, because
either the examining authority in the medical college is not doing it properly, which we cannot accept because they are specialists. Then the question is that your district authorities are playing a farce in the matter.
Lordship, inside.
They are issuing certificates without proper assessment.
Lordship, to
What
that,
steps have you taken?
Lordship, till date, Lordship, we have not taken any steps. but
Then
Lordship,
we will have to go in terms of the PWD Act. That certificate has a value.
Lordship, that is only under Lordship challenge before this. That order, Lordship.
Which one is that?
26. 6 to 2000. Division bench. At Boston Station.
Mr. Monto, the same very issue is pending before the division. Same thing, that OM dated 21/5/2022, interpretation is
That
pending.
OM
OM.
has a different, in my case, that OM is not
But
applicable.
the issue would be the same thing, whether they will have the power to re-verify.
Ultimately, they may go into it, but my question is, in this present case, the OM which was issued, it was later on.
No, we'll not go into that, but the principle is, the issue that would be required to be considered is whether the appointing authority has the power to make further verification of the physical disability status
Yes.
of the person,
Of the
candidate
person applicant.
concerned, and arrive at a contradictory position than what is already. Because see, here the question now is, if you're 18%, you are not even entitled to participate in the, as against the PWD court.
Exactly.
It's fixed on 30th of
30th of
April.
April.
30th of April. You can do one thing, you can make a prayer before the division bench. You can have this matter also along with that. You can put in an application so that your arguments will also be there before the court.
That's why, if I can intervene in some way.
Some way means, only way is that you can submit an application on the administrative side to the Honorable Chief Justice for tagging of this matter with that. Because if that matter gets decided either way, it will be binding on this matter also.
It may have impact in my case. In my case.
Mr. K.K. Mont, Mr. D. Upamanyu, Learned Counsel for the petitioner, for the respondents,
Health and
submits that the issue raised in the present writ petition is pending consideration before the division bench of this court in the case of writ appeal number in WA number 37 of 2026. Mr. K.K. Mont, Learned Senior Counsel appearing for the petitioner, submits that the matter be taken up after 2 weeks. And in the meanwhile, he shall examine the alternatives available to the petitioner in the matter. So, prayer accepted, raised it to list this matter after 2 weeks on a date to be fixed by it. I have my reservations here. If you don't take consequential action on your district authorities,
Yes.
then that cannot be held to be, because this court cannot say that who is right, who is wrong.
Yeah.
yes, Lord.
And the district authorities, they are backed by the provisions of the Act. I've been thinking over this for a long time now, but I've not got a answer.
But Lordship, at
I
times,
thought today I'll get it from Mr. Monto. Anyway, we are. Yesterday also the same issue came up before me. This is troubling me, Mr.
Lordship, at times there is a chance of variations also in some candidates, Lordship.
A variation of 5 to 10%, even 15%
there.
I can understand.
Yes.
But 40% to 18%, yesterday I had cases. 40, now 18, 12, 10.
But see the conduct of the authorities in no other department, in no other election process.
Mr.
They have gone
Pomanno,
for.
ask your department, because see, this is a thing with a particular object, PWD.
Yes, Lordship.
It's to bring a particular section of the society into the mainstream.
Yes, Lordship.
They are given an uplift. Now, if fraudulent people, if others are allowed to get these certificates fraudulently, then you are defeating the purpose of the Act and also causing prejudice to the already marginalized people.
Yes, Lordship.
Now, one thing I'm giving you an example. This finger, right finger, this is called I think the index finger.
Index.
Now here I have a problem. Say it's not weak. Now I know it personally. Now this disability, this is a disability.
Yes, Lordship.
It's 40% or
No.
50% because I'm not using my arm properly in relation to my palm. But it is projected as 40% disability to the complete body. When considered with my body,
It is not even
this
5%.
disability may not be 40%.
Yes, Lordship.
That is the place where the game is taking place. And I'm sorry, the authorities are doing nothing in this matter.
But exactly, my lord, I don't see any reason. Any
Because
reason.
till you don't identify that, see, this is the disability projected, we have measured it. Because in your reports also, you will not find that 18% only there, right? How 18%?
Yes.
Lordship, that
You give us that data. That's 18% because of this.
Yes.
This is the disability. This is the extent of he is incapacitated from using that.
Lordship, in some of the matters we have given, Lordship. In this also, there will have to be the records.
We'll see.
Yes, Lordship. Obliged, Lordship.
Obliged.
Mr. Gogoi is come. Mr. B. Gogoi.
There is a matter there.
See, this matter is pending, Mr. We have to keep a senior counsel waiting.
I apologize for that, Lordship. We are also running.
Well, SSA is also a party. No?
Now, Mr. Monto, in your that motion matter,
Yeah.
how many of the people TET candidates, CTET candidates are in the fray now?
There are.
300 and something.
Yes. Yes.
Huh?
Yes, that is it.
That much only, not 961,
No.
only 341.
Yeah.
Division bench said 961, do, and thereafter what you do, you do.
Including DWE and.
I'm coming to that. I'm coming.
916 include.
961 you do,
Yes.
and the rest, whatever you want to do, you do.
Yes.
Then,
They came up with the plea that we have concluded the
no, forget it.
election.
Then there was another writ petition 70 something.
Yes.
Therein, the plea taken by you was that now that only reserve candidate posts are advertised, so we may not get a chance.
Yes.
You unreserved may not get a chance.
Yes.
Court laid down
Yes.
that either de-reserve
Or
or
last come. first.
whoever is below
Yes.
in merit,
Yes.
they will be put back. Now that stage is also gone,
God.
settled. Then the latest decision by my Lord Justice Pukon,
Yes.
wherein he has gone into the depth of the matter, considered all the issues,
Yes.
and said, division bench judgment, you cannot violate.
Yes.
You cannot violate the coordinate bench judgment in 70 something.
Yes.
Then he said that the CTET candidates be given the thing. Now, you are only, now the post is around 1300 something. How much posts are there?
Also that that were reserved that by division bench judgment.
961 posts.
916 has to be divided into two. The breakup has been given by the division bench. 916 includes DEE and this contractual teachers. That falls to 315 for contractual teachers.
So now we are concerned with contractual teachers.
350.
So 315, how many teachers are there?
Now, candidates,
They have been called 342.
342. So how many posts are vacant now?
We have to consider it.
normal, what they say, post, going by the decision in that Justice Mr. Bhuyan,
Justice Fukan's decision.
Kokan as well as Justice Mehdi.
Mehdi.
Yes, what they have said.
Mehdi's judgment is unfortunately not on record,
Oh.
but the extract is
The
there.
extract is-
Well, there, it was said that plea was raised that post for general categories is not open or filled up.
That is also settled. We can't go into that.
Yes, now therefore, the question is, these 314 or 341 people are waiting. You consider their case. You
No, I want that. How many posts are there?
post, they will have to accordingly accommodate. If
No, they have disclosed that. Hey, file diya hai, 37.
post of Kankadu.
Over 37.
This is 102 may be seen.
Yeah.
Also, page number 102 may be seen. 102.
That division bench decision.
Forget that. Now, how many posts are there?
Now ultimately,
That's still in.
it was it. এটা তোমাকে advertisement কি করছিল?
Same advertisement name.
Yeah. There is no fresh advertisement. They will have to now take up the cases of those.
Now, what is your apprehension?
My impression is now, instead of considering these seated candidates, instead of considering them, because the whole process is now opened up only for consideration of seated candidates. They claim that normal procedure was taken to a close. All people who were there, stated candidates, they were all considered and they
Two
were
issues,
appointed.
Mr. Bonto. One, you all had submitted applications either offline or online in terms of directions passed by the school. So whoever had submitted application,
Yes.
they are only to be considered.
Considered.
Others,
No.
there may be hundreds of TET candidates, seated candidates, they are not considered.
Not considered.
Only the candidates who had, my Lord Justice Pathak's order,
Yes,
who had submitted the forms either online or offline,
yes,
they will be
they
considered.
will be considered.
Division bench's order is also limited to that extent,
Yes.
as we understand.
Yes,
Now, division bench, there are two categories. One is the direct recruitment in the
the,
normal schools,
yes,
normal posts.
Normal post.
Another one, SSA.
SS,
Now, we are concerned here with SSA,
SSA.
contractual appointment.
yes.
Then the grievance raised by you is that because they have now projected, they don't have any reserve posts, they don't have any unreserved posts, they don't have any EWS posts, the posts are of reserve community.
Yes.
So you came up, one round of litigation, my Lord Justice made his order 70 something, saying that either de-reserve,
Yes.
which Mr. Nayak objected to,
Yes.
which then said, okay, consider merit whoever is there,
Yes,
lower than them, bring them down, put them in.
yes.
So that position still holds the field.
That's the position still holds.
Then you again had to come up before
Yes,
this court in 6321 or something, my Lord Justice Fukan's order,
It was for contract.
wherein everything was looked
Yes.
into, and final direction is
Yes. Open.
para 15, para 14 and 15.
Yes.
Now tell me what is being violated here.
Now,
What happened? The judgment of
no, the principle followed is the same here.
No,
also.
Mr. Monto,
Mala.
we'll come to that TET Assam thing.
Yes.
But what is the problem? How is the violation of 14 and 15 taking place in page 148?
This is shortlisted applicant has been called.
Malad, firstly, following the order of this court,
150 page.
at page 150, Lordship will see,
Annex 9.
Annex 9. This is the, in compliance of the orders of this honorable
And
court.
they have now prepared a list from 151 to 150
Yes.
179,
Yes.
342
This
candidates.
is 151. This is a shortlisted candidates.
Ah,
These are all seated candidates.
ah,
These are all seated.
ah.
Now,
And they will now have to be considered, now that they have been shortlisted, they'll have to be considered in terms of, forget the earlier decisions, the latest decision 14 and 15, para 14 and 15.
exactly.
That's all.
That's how. They could
And-
not have bring in now fresh candidates from.
Oh, let them bring him from wherever they want,
Yes,
but
but-
without considering your cases,
Yes.
this will, that much only you require. Yes.
So far, renewed form of consent, most of the petitions, they have already been given appointment, Lordship. I think my senior friend has appeared in that contempt case. The contempt case is pending. So
People have been
except-
appointed.
yeah, except NIA.
That is for
who are
the
NIA,
administrative
Lordship.
director. Will.
Director of it, that is a regular post. This is contract.
This is contractual.
Mr.
Then NIA will have to appeal.
Lordship, I will appraise Mr. P. Nayak as well. He's also on legs, Lordship. Just for some time, Lordship. He'll be on his way, Lordship.
Because yesterday they have carried out the verification of this, the illegal, all these candidates without considering us.
Mr. Mohanto, my question is, let them do whatever they want to do. Let them consider even from outside. But in terms of the directions passed, the repeated directions passed, without considering seated,
Yes,
whoever are in the fray, they cannot go proceed further.
exactly. That is what I want. That protection Lord may give me.
That what is required for me to give. It's already there, 14
Already
and
there,
15.
that unfortunately has to be now again reiterated because
No, that's what I am thinking. Why should it be reiterated? Because
you will see.
No, no,
Otherwise, this
that's
whole
what I
of-
want to ask the Standing Council SSA. Why is it required that each and every
Except
time
every time we have
the
to come.
petitioners have to come here?
Otherwise,
And
there,
shortlisting means you are found eligible in all the criteria mentioned in the division bench, right?
exactly. Yes. And they have said in that 180.
No need to come. You no need to come
No need to come.
because you are already the verification as. Okay. If they come. Otherwise, after some time, we will take it up and pass orders.
Well,
Much obliged, Lordship.
Nala mati dia, timing kita mati dia. Where is that order?
That is not unless, but in the, that is available with me, Lordship. I can, the position that was wrong.
Yes, who is appearing? You have retired.
No, Lordship. I have for 2 years left, Lordship.
Yes. The only thing is that these aspects have not been incorporated in your service book.
And I have not been furnished a copy.
We are passing an order
Yes, Lordship.
The government.
directing your future consideration of pension in terms of our order. We'll say that any entry made in the service book, not updated, will be read with the updated order for all intent and purpose. What more is required?
Yes.
Yes.
Lordship, the
Why
government.
is the service book not being updated? Because what happens is, once the pension proposal is prepared, it will be prepared on the basis of the service book.
Service book.
And the AG will catch up. Now, see, he has 2 penalties. Why have you not reduced? Rightly so. So these updates have to be given.
Lordship, that the governing body will have to give him.
Yes. Heard Mr. R. Sharma, Learned Counsel for the petitioner. Also heard Mr. D. Upamanu, Learned Standing Counsel, Higher Education Department.
For 1 and 3.
Also. Issue notice returnable 4 weeks. Mr. D. Upamanu accepts notice on behalf of respondent number 1.
1 and 3.
1 and 3. While Mr. G. Pegu, learned government advocate, accepts notice on behalf of respondent number 2. So, no formal notice, it will be petitioner to take steps for service of notice upon the respondent number 4 and 5 by way of registered by way of speed post as well as by way of dusty mode routed through the registry of this court. In the event the notice is so served by way of dusty mode, petitioner to file an affidavit after effecting such service. Also, the respondents number 4 and 5 on the next date of listing shall apprise this court as to why the order passed by the appellate authority dated 6/1/2019 withdrawing the penalty of stoppage of 2 increments imposed upon the petitioner by his disciplinary authority has not been incorporated in his service book as alleged by the petitioner herein. Also, your increments have also not been regularized.
Lordship,
You have got back your 2
I am
increments.
getting it, but there is some wrong entry, Lordship. There is some wrong entry.
What wrong entry?
Because 2 increment was stopped, but it was shown that 3 increment has been. So,
Now have you got it back?
I am getting it, Lordship.
Also, registry to list this matter again after 4 weeks on a bit to fix.
Obliged.
You are held to be an insubordination by charge of insubordination against you.
Yes, Lordship.
So sometimes some things, other things also act.
That's true, Lordship, but the thing is that some misconception also in the mind of the authorities.
That misconception is created by you.
Obliged, Lordship.
Yes, Mr. Doctor.
Lordship,
What is happening?
Lordship, that instruction is awaited as per last order, Lordship.
Hmm.
And the petitioner's main given is that out of 87 posts, as per him, Lordship, all posts are not advertised. So in that aspect, Lordship, my submission is that petitioner cannot claim how much posts.
That is only
No,
submission.
subject to.
If that is your submission, I am disposing of the repetition
No,
now.
Lordship, that instruction is awaited.
Then why are you making that submission?
No, but this
Come
is-
to the rules. This is headmaster.
Lordship,
Now come to rule 3.1. Sorry, 14.3.1.
14th, Lordship.
So,
Could I end up
shall make an assessment of the number of vacancies to be occurred in the cadre of headmaster, superintendent, and to be filled up by promotion in the next year.
Lordship,
So,
my understanding subject to correction, Lordship.
I'm sorry, this is the vacancy, and if you are holding
Lordship.
that we don't want this post of headmaster, you cannot fill it up by keep it and fill it up on in charge basis.
No, that is not my submission. My understanding in this, Lordship, employer may assess, Lordship, how much the vacancy they have as part.
But you have the discretion not to fill up all the posts.
Whether he has any right to claim that.
No. First, show me your right, your discretion.
Maybe there are some discussion.
Okay.
Maybe, Lordship.
On the next date of listing, Mr. P.T.
Lordship.
Learned Council for the Learned Standing Council, Secondary Education Department shall place on record the reasons basing on which the authorities had decided only to fill up 63 vacant posts of high school headmasters in provincialized high school in the district of Borpeta out of the 87 vacancies arising in the matter.
Lordship, there will be more, Lordship. 48, Bajali, there is no inspector of schools. So a combined.
Mister, I'm only going by what is here. 87 and 63. That is the order.
Because in Bajali also, Lordship, they don't have an
In your
inspector.
writ petition, how many you have sent?
87, Lordship.
Then
Paragraph 10.
so why Mr. Das bringing up something which is not there? Mr. Dotto had projected that a discretion is available with the respondent authorities not to fill up all the vacant posts arising in the cadre of headmaster in a particular district through the same selection process. In the event the said instruction is not placed on record by the next date of listing, the concerned authority who had taken the said decision shall appear online before this court on the next date of listing. Shall appear on video conferencing before this court on the next date of listing. Registry to list this matter again on this take a very much. Pulling an idea. 27 3/2026. Now you get
That
it.
was my submission from a lawyer, Lordship.
Not lawyer.
Not on the.
No, submission, that's what I want. Let us test, because that is the logical thing you have done.
Yes.
It's not a submission
Subject
which
to.
is without logic.
Yes, that's it. Subject to instruction coming from the department. This was my.
Let's test that submission.
Being an officer, I am placing that my.
You heard that, and I want that to be done. Because that is one of the plausible things. If there is no decision to that effect, fine, forget it. That's the end of the matter. If they have something else, bring that on record. We are not holding you only on this.
No.
But you have raised a good point. That if there is a genuine reason, we'll ask him to go. But you get that?
Lordship, there is an interim order also.
Interim order passed earlier to continue till the next date of listing.
Obliged.
Yeah, move it.
Make it a lawsuit. But this matter relates to property.
What is your case?
My lord, by ignoring my case, my lord, the private respondent has been, my lord, his service has been provincialized.
Who is senior?
Though he was terminated from the school.
Terminated.
Yes, my lord.
That is the point.
And his name does not reflect in the dice data, my lord. In the inquiry report also, he was not found in the school. He was.
This is under the 2011 Act.
My lord.
The regular provincialization is under the 2011 Act.
Lordship, kindly.
And where is that termination?
Termination lawsuit.
Who is appearing for the private respondent? You are appearing?
Page 24 is the termination, my lord.
Where is your corresponding statement to this in the writ petition?
Paragraph 5, my lord.
So on the date when the his name was not forwarded to DSC.
Not forwarded.
And you also knew that its name was not forwarded onto the DSC on 22/7, before 22/7/2004, as he was already terminated from
Yes, ma'am.
This was known to you. Are you sure?
Yes, ma'am.
I'll not ask you to, I'll not permit you to resign now.
My lord.
I'll not permit you to resign. And Mr. Soikia, this is a very serious case. Now come to the earlier writ petition. Where have you taken this plea in the earlier?
Earlier writ petition, my lord. Earlier writ petition, that is up to 2013 writ petition, my lord.
Kiman asile to? Writ petition to
Seven-
WPC 2746.
My lord.
Mohan Chandra Pradhani.
Yes, my lord.
Therein you have filed detailed affidavits. Where is this plea? Because 2023, what you are saying, you knew in 2013 also, because this is the incident of 2004. Huh?
That is true.
Where is your plea to that?
That affidavit, my lord, I do not have.
Okay,
I'll let my lord.
have this file, go through it. We'll take it up after some time. And Mr. Soikia, if you are pressing this writ petition, this court will be very severe. This suppression is not expected of a teacher. And there are many other materials. There are many other materials. Go through it. You may not be aware.
My lord. Earlier under litigation, I was not there. My lord.
That's what I'm telling Mr. Soikia. Please go through that.
My lord.
Go through the affidavits of respondent number 7 also, the headmaster. He has said that it is the respondent, your father, and you had played the whole game.
But then why the name of the
Oh, this is something there. Why it went? You will find it in the earlier proceeding. And Mr. Soikia, if this is the ground you are urging now, not there at that point of time, there is an FIR against you, complaint against you by the principal, saying that you had taken entire records, not you actually, the LDA of Inspector of Schools. He and you both together had manipulated records. Go through that. We'll take it up at the second half. You just go through the. And thereafter, if you wish to press, welcome.
I will press, my lord. I will
No,
press.
if you-
Whatever
after going
I have
through that-
instructed, my lord, I will press my petition, my lord, as per my instruction, my lord.
No, you just go through
Lordship
that.
may take any decision.
No, you go through that first.
My lord.
You go through that.
Well,
I don't want to pass an adverse order without giving you notice. Go through that. Yes, Mr. Bora.
I've given a short list of dates, Lordship, as required. Only 7 important dates. Lordship had asked me to make a short list of dates. I had done.
Yes, Mr. Bora.
EML, the period which he has not been present in the work, that has been counted as no work, no pay, my lord. And my lord, regarding his other part, my lord, his regularized for pensionary benefit, my lord. His other part, my lord, his services regularized for pensionary benefit, the period he was absent, my lord.
Yes.
The period which they show, Lordship, which I did not get payment, which I have challenged here, Lordship.
Have you worked during that period?
No, Lordship, because they did not allow me to work. I have specific allegations I have made in the writ petition. The headmasters did not even receive the notice sent by this honorable court. And he was not, and during this period, Lordship, litigations were there before this court. That's why in the show cause also, I did not challenge the natural justice. Well, I said that since this litigation is going.
That show cause has been set aside.
This idea, because I did not take that plea also, because it was a first on the system, Lordship.
And thereafter, they have not initiated any proceeding against you.
No, nothing. They cannot, Lordship, because the list of dates, Lordship, you'll see between, I am asking my salary between 1/3/2019 and 8/6/22, Lordship.
Salary for the period?
8/1/3/2019 and 8/6/22. Till 1/2/2019.
1/3/2019 to
8/6/2022.
During that period, my lord, petitioner was absent, my lord, unauthorized absent, my lord.
Anything more?
Lordship, if this 1/3/2019 is there, Lordship, till there, no approval was given for me also. When there was two orders of this honorable court, Lordship.
The period before that you received, there was a complaint, there was a charge against you, but they did not proceed. So
No,
we need not go into that.
Yes. There was, that charge was not good enough, Lordship, because I was, yeah,
That was quashed. They have
first,
not
yes, Lordship. Yeah.
heard Ms. S. Parveen, learned counsel for the petitioner. So heard Mr. T.K. Bora, learned standing counsel, secondary education. Elementary education. And Ms. D. Mushari, learned standing counsel, secondary education. Hearing concluded. What date diya? Khali. 1/4/2026 for delivery of us.
Lordship, 2017 judgment still stands. The first judgment, but can I take? Can I take?
You've got it.
Yes, 2017 still subsidies, Lordship. Obliged, Lordship.
Obliged.
May I please, your Lordship, on the last occasion, the hearing remained inconclusive, your Lordship.
Yes, yes. Please proceed.
Lordship, D. Bora will appear in this matter. He is legs in court 23, Lordship.
Lordship.
After sir.
Made to the Lordship. This
Yes,
is
yes.
relating to continuation of service, my lord. Terminated,
Yes.
then my lord
Yes, Lord.
reappointed.
Madam, you have made your submissions. You can,
Yes.
you have got your submissions. Yes.
May I please, your Lordship. Lordship. Particular petitioner has filed before this honorable court, Lordship, and honorable coordinate bench of this honorable court, Lordship. WPC number, Lordship. Coordinate bench already has been decided, Lordship, pass and order, Lordship.
WPC?
Order dated 14/7/2020, WPC number 6020/2017, Lordship.
What was decided?
Lordship, they are not entitled for the earlier
Prospective.
continuous service.
Where is it? Why the court held in that manner?
Yeah. Hello.
Initial appointment was by the state government, Lordship. Subsequently, it is a 221.
But service regular for it.
As per policy decision.
Continuation.
Yes, series of case findings. Under the policy decision. In our affidavit also same stand has been.
Madam, have you gone through this decision?
I don't know, my lord, which
Has been taken.
judgment.
Our affidavit also, as per the policy decision,
Because my lord, my submission is, my lord, they were appointed together.
reappointed has
together,
been made, Lordship.
And my lord, in persons of the.
But why this discrimination between certain sets of
Yes.
people petitioner? They were on 4-5 together. 3 you have given. The petitioner was left out, right?
Lordship, please come to our affidavit, Lordship.
Which affidavit?
third number affidavit, Lordship, page number 87, Lordship.
Read.
Page number 87, relevant paragraph, Lordship, paragraph number 2, Lordship. May I read relevant paragraph, Lordship? It is pertinent to mention herein that the Executive Council in its meeting dated 24/02/2014 decided to withdraw the termination order on fulfilling the terms and conditions laid down by the Director of Elementary Education Assam with prospective effect, Lordship. That is what, that is the prospective effect. Terms and conditions given by that policy. And
Then why were the people appointed with retrospective effect?
retrospective is already in this judgment, Lordship.
No, we have orders here.
Yes, Lordship.
We have
Out of
orders
them-
here in the writ petition. If you come to page 48, 47.
Yes, 47.
147.
Only
Only
47.
47. This is in compliance of this honorable court, Lordship.
Then why was it not followed in respect of the petitioner?
This is followed in the year, Lordship.
19, the petitioner was also there waiting.
Petitioner thereafter, Lordship. Petitioner
Is there from this two persons from beginning.
this person, not only, Lordship, our groups of 221, Lordship, in this judgment, Lordship.
Which judgment? This judgment.
This judgment,
This
Lordship.
one.
221 of numbers of teachers.
The petitioner is also here.
Not there, Lordship. In our affidavit, this is very clear, Lordship.
No, I don't get you. Means why Imtiaz Ali was left out, but other three were brought in. That much only I want to understand.
Kindly, Lordship.
What is this, madam? What is this WPC 59 of 2013? Is it on record somewhere?
59, yes, my lord. I think judgment they have. Is here.
WPC 59?
No, not particular it, yes, my lord. They were talking about that.
In this judgment, Lordship, our state and state government stand is very clear, Lordship.
59 of
59.
2000.
These are all
They disposed of 28/11/2017.
Judgment they have not enclosed. Actually, I have enclosed.
Madam, you just go through this judgment once. This may have some bearing.
But the decision is, my lord, the minutes of the meeting. If your lordship come
No, I'm not on
to
that.
70,
The second regularization has also been taken care of by the. Here. Right from the decision of the division bench. Subsequently, it was done and the final objection is that they are only entitled from the date of second regularization.
this is second regularization, Lordship.
So if that is the finding of this court,
earlier, my lord, one person, I don't think so, my lord, that twice it can be regularized. Earlier, my lord, before.
no, I understand,
termination,
but
yes.
this has been in detail considered here. You please go through it if you can
Yes, madam.
distinguish it. Because it's a decision of a coordinate bench, it is binding on me also.
Our affidavit also.
Mr. BC Musahari, Learned Standing Counsel,
9%.
PTC has placed on record a decision of a coordinate bench of this court dated 14/7/2025, rendered in WPC number 6020/2017 and submits that the said decision
2013.
would also cover the issue of the petition raised by the petitioner in the present writ petition.
Excuse me, my lord, for a minute. Your lordship talking about that case number 59 of 2013.
No, I'm talking about this latest decision.
Latest decision,
This is of 6020-2017.
2017.
17.
6020.
59 is the order which relied upon to regularize the services of your two other colleagues.
Yes, my lord.
In view of the above, Ms. N. Soikia, Learned Counsel, appearing for the petitioner, submit that she be granted 2 weeks' time to peruse the said judgment and make her submission. You just peruse this judgment, make your submission. Give a copy of this. You can remove the thing, only we want the body. This much. And the first page.
A date may kindly be fixed, my lord, as per your lordship.
Registry to list this matter again on 26, sorry. 24.
24. Obliged.
Deeply obliged.
My lordship, may I please lordship. Lordship, I file affidavit that may be called for lordship.
My lord, item number 14, stand in the earlier petition was completely different, my lord. I will have to call the client, my lord, to take instruction, my lord, why.
You're not adjourning it. You are under instructions to argue, you please argue. Because I got it. Mr. Soikia is everything I know. Mr. Soikia will be taken out of, this will be a blow out of blue for you. That is why I made it. You are under instructions to argue in a particular manner. Please continue with that. I just wanted to bring this to your notice. I'll pass my orders, don't file them. We'll call it in the second round. No. Mr. Naik, what is the purport of this page 150 and 180? And in connection with the directions passed by this court in the earlier round of litigation?
150 and 180. Yes, lordship. Lordship, these petitioners are seated candidates, lordship. Division bench as well as subsequently learned single judge lordship directed to consider their case as well. If lordship comes to page 135, lordship.
135?
Annexure 8. This is the last judgment, lordship. Lordship, this was the petition, lordship, filed by the petitioners.
Para 14 and 15 gives the requisite directions.
Yes. Before that, lordship, if lordship comes to page 143. 143. Down below, lordship, 8.1. However, as clarified by this court, the selection of writ petitioners, they are seated, appellants, would be subject to the condition that they have other qualifications prescribed in the guidelines issued by NCTE, and they have to fulfill all eligibility norms prescribed in the earlier advertisement dated 24/9/2020, which includes necessary proficiency in the required language, and accordingly, appointment of the writ petitioner's appellant has to be considered only after examining their eligibility and merit amongst all eligible candidates who are assumpted qualified candidates and have already applied in terms of the said advertisement dated 24/9/2020. So when I am going to
read that, complete it.
Yes.
And that eligible candidates.
And the eligible candidates include the original applicants who are assumpted qualified candidates and also the seated qualified candidates who were petitioners before this court and who have applied in terms of the advertisement dated 2020.
Now, Mr. Naik, as we have understood it, the division bench said there are two categories. One is the direct recruitment that posts, and the other is under SSA, contractual appointments.
Appointment was, two appointments were there. One was issued by the government, that is for permanent recruitment. another by the SSA
This
Lordship
is
for
what I'm saying.
contractual appointment. Yeah.
In the
The original direction was passed by the division bench in the case of the government Lordship.
But subsequently, same
Subsequently,
direction.
same direction was applied.
So now,
in case of
now in both the cases, SSA as well as DE, the same directions apply.
yes.
The court said first 961 both amalgamated. 961.
In the first case, Lordship, when the direction was passed, appointments were not yet.
Oh, the total posts involved in both the cases, DE and SSA is 961.
No, I have that there is a difference. There is a difference of. In the case of the government Lordship, the appointment letter was yet to be issued. At that point of time,
What
order
are the
was
total
passed.
number of, what is 961?
961 were the seated candidates.
No.
916, 900.
Then you have not got the order correctly. Then
Lordship,
it is
Lordship,
961 is the number of posts.
Lordship, page 64, Lordship.
Page 102.
I'm coming, Lordship, page 64.
Come to 102, that's the final order.
Lordship. In the first page appointment, Lordship, that is why I'm pointing out the differentiation. In this case, Lordship, appointment letter was yet to be issued. Therefore, court segregated.
Today we are not going into that. Come to 102.
Yes.
That is the direction.
If in the first page appointment orders of filling up 3025 out of 3941 vacancies may be issued from among the state TET qualified candidates. The appointment orders in respect of the remaining 916 vacancies to be issued to the eligible candidates in the second phase after considering the candidates of the 916 writ petitioners. All these writ petitioners were seated, which includes the present petition appellants who are central TET qualified candidates.
This 916 vacancies, is it both DE and SSA or only DE?
Only DE.
From where do I get it?
This writ appeal 24 pertains to the advertisement issued by the government only. It is not by the SSA Lordship.
Yours is 69.
My one is 69. And one difference Lordship will see there, if Lordship comes to paragraph 53 of the judgment, page 101, the first judgment, appellate judgment, 101.
Page 101.
101. Paragraph 53, Lordship. There can be no doubt about the fact that the ultimate beneficiary of this recruitment process would be the large number of children who may suffer if there is undue delay in appointment of teachers. We are also conscious of the fact that there are 3941, this is by DE, vacancies advertised by the department, and the total number of writ petitioners who had approached this court is 916. We make it very clear that all these 916 candidates shall be considered against the existing 3941
There is the order
vacancies.
passed by the division bench in the case of SSA.
That is 69 of 24, Lordship, second writ appeal.
Where is that?
Page number? I got it, sir.
135, 135, 135, 135.
135, no. Writ appeal 69. What? That was
69, wherein the SSA candidates are involved. Where is that order?
yes, page 55, Lord.
55.
Yes, Lord.
Okay.
Now, this is a case, Lordship. Same order was passed. Although one thing is not to be noticed, Lordship, when this order was passed on 19/7/2021, we have already given appointment to the Assam candidates, Lordship. And we had to consider these petitioners only in the remaining vacancies.
Just a moment.
Main judgment to judge. You put this in the. You put this in. Main.
So the petitioners, appellants here, this case would now be covered by page 62 order. And that copy paste the order passed in the DE recruitment, right?
Yes.
So then you had issued a vacancy breakup. You had issued a vacancy breakup.
That is why I am submitting, Lordship.
That is at page 134. This is SSA.
Yes.
This is SSA.
134 is SSA, Lordship. Yes.
So this was the vacancy which now existed after you had made appointment of persons
Yes.
from Assam State.
Assam State only.
This was put to challenge in 7007.
6331.
No.
70 is another case. That is again DE case, Lordship.
Oh, that is again DE.
Yes, Lordship.
Okay. Then this was challenged by SSA in 6331.
Lordship, after the order was passed by the division bench, we issued advertisement showing the remaining vacancies, opening it for the seated candidates.
In DE or in this one?
SSA. This case pertains to SSA only, Lord.
Similar exercise in that one also.
That one in DE also did the same exercise. In the remaining post, Lordship, we issued the advertisement. Now, these petitioners were unable to apply because in some categories, posts were not available. Suppose he is a general category candidate. In the remaining vacancies, no general category post was available in a particular
district candidates had not applied in pursuance to the 2020 advertisement. They had submitted their application thereafter.
Yes.
When?
Lordship, prior to that also, some candidates were in another date petitions. They submitted some applications. Those applications have also been considered in the new exercise.
But
they
then the second opening was given to the seated candidates to submit application.
Some of them applied because it was an online application, Lordship. If the post is not available, the computer was not accepting their application. That is why they filed this second case, Lordship, 6331/2022, that is phase 135.
Here also, the court reiterated that the order in 7000
will apply.
Will apply.
But in the process, Lordship, court made it clarify that while doing this exercise,
that the division bench's order is already there.
You have to consider the Assam State candidates also.
Okay.
If their merit position is above you, then definitely he will get the opportunity and you will not get the opportunity. You have a right to be considered, but you cannot claim a post if you are below in the merit list, Lordship.
Now, you have prepared a list at 151.
Yes.
This is after the order passed by this court in 6331/2022.
Lordship. It was very recent.
Now, this is the final list.
This is the final list, and pursuant to this list, Lordship, at page 180, Lordship will see the verification.
Now, verification is already done. They are not.
So far as seats are concerned, their verification is already
Now,
over.
who are these Assam State candidates?
Now, remaining
These Assam State candidates are candidates who had
applied in 2020.
They have not been appointed.
They were not been appointed because at that point of time, for them, posts were not available. Suppose a general category post is not available. That is why, although he was in a higher position in the merit list, he could not be given appointment. Now, after the court's order, Lordship, we created more posts in the general category. In this case, Lordship, 149 posts. So now we are considering whoever comes within the merit zone of until 149, Lordship, be he a Assam State candidate or a seated candidate.
They will be given equal.
Equal. If his position is, if his merit position is higher, then he will get an opportunity above the seated candidates.
Okay. Yes,
so that is why my submission. That is why my submission, Lordship. On the face of this writ petition is not maintainable. So this may be dismissed, Lordship.
Well, fine, my lord, now does it appears? It appears the cat is out of bag now. How they are trying to eliminate these candidates by taking.
Mr. Monto, just to understand what he has said, means what I have understood, I'm just so that you can put it in perspective.
Yes.
Mr. Monto, Mr. Nayak is submitting that 916 is actually in respect of DE. The principle thereof is applicable to you also. He accepts that.
That is
also
factually
accepts-
wrong. That is factually wrong.
How?
916 is the total number of seated candidates who have applied in DE as well as in SSA. Because when
But now, but now you're not there for the all the candidates. It's only around 342 who is in the fray.
exactly, well, because in seated
Now tell me one thing.
SSA,
We
only
got it.
341.
We got it. Forget it. Just to negate what Mr. Nayak is trying to submit.
Yes.
Mr. Mohanto, your grievance before this court from the word go was
Yes.
that seated candidates were being deprived because they were not considered
Yes.
eligible for participation in the inquiry.
Right.
Now, the situation would be if you are eligible to participate in the inquiry,
Yes.
your appointment will be in terms of your merit position.
Right, exactly.
Now, this court has already provided that if the de-reservation of vacancies is not permissible, then your position would be who are the candidates who have already been appointed, the merit has to be assessed, and if you are above them, they'll come down, you will get in. So now, those two orders are there. Those two orders are holding the field. The consideration of the Assam TET candidates, because they say they have vacancies more than 342 now. How does it prejudice you? If these two principles in para 14 and 15 of the earlier judgment is applied?
My lord, now for the time being, Lordship will see my learned friend referred to the division bench order saying that even the qualifications and along with the Assam TET qualified candidates to be taken into consideration. That was corrected. That was a mistake.
No, that he has referred in the decision of the coordinate bench.
No, in a division bench. No, my lord, what I found.
That is page 144.
43, dollar paragraph. 43, A paragraph.
Acha. 144.
Hmm.
Let me read it. 8.1.
Right, Mr. That is what you read.
However, as clarified by this
That is immaterial, Mr. Monto. That is not going to.
No,
because now you have been finalized. This 342 is finalized. Everything is complete.
Now, kindly see, how am I prejudiced? Because the direction and the requirement was to consider the merit position of the seated candidates only. And it should be put against those candidates who have already been selected and appointed.
Now they can't go beyond that. They will have to.
Yes. Now they say, no, what happened? We are not touching those candidates.
We are making it clear. We are clarifying that position.
Few candidates.
We are clarifying that position.
Yes.
That the direction of this court, which summarizes everything.
Everything.
In para 14 and 15.
Yes. Therefore, in that case.
At page 148.
This was already there. They should have understood it clearly. Well, it doesn't leave any ambiguity to understand.
And still that we cannot blame them because that end exercise has not been achieved. It's an apprehension till now.
Well,
it's an apprehension. It may be a bona fide apprehension. It may be a true apprehension. It may even translate to that. But it's still an apprehension.
Kindly see, what they have ultimately advertised is that no posts are there, only few reserved posts are there, and general posts are not there. Therefore, how can you be considered?
Mr. Naik, one submission, one query. Page 151 is the final list. In compliance of every requirement under the division bench order, earlier order, done. Is this the final list?
I think no, Lord. No, Lord. Vacancies have been created
Hmm.
by, I mean, earlier it was a reserved category post. Now that reservation has been done away with, and now the post is a general category.
Now, how are their merit to be assessed? Who will assess their merit?
Lordship, initially we issued an advertisement in 2020. Subsequently, after division bench's order, we issued another advertisement. Pursuant to that order, some candidates applied.
That is just an invitation. That cannot be an
I'm just
advertisement.
giving the number, Lordship. First, we considered how many posts we are required to de-reserve. There was an earlier judgment, sorry.
No, I'm not on that. This court required you to either de-reserve equal number of posts for them or consider them on the basis of their seniority and the Assam TET candidates who were already appointed.
No, seniority will not come, Lordship.
Sorry, merit.
Initially, they were not eligible. Division bench passed order. We issued an advertisement. Lordship, I am clarifying.
I'm sorry, Mr. Mr. Naik, that second advertisement is no advertisement in the IOP.
No.
That is just a continuation.
No. Division bench passed an order. Accordingly, we gave the vacancy positions. That is.
Division bench never asked you to publish a fresh advertisement.
Lordship, in the first advertisement, in response to the first advertisement, they were unable to apply. So they are
not applied offline.
Offline, those candidates we are considering. Those candidates we are
Today
considering.
you have 342 candidates.
That is what I am submitting, Lordship. After the division bench's order, we issued another intimation or advertisement. Pursuant to that advertisement, some candidates applied. We have considered those. Thereafter, Lordship, after the learned single just passed the order 6331, Lordship, we issued another advertisement. Then also some candidate applied.
Why?
Lordship, because we were required to de-reserve post, Lordship. And
you
we
had
were not
issued that advertisement only for seated candidates or Assam TET candidates?
for seated only.
Seated only.
Yes.
Why? Who asked you to do
Because the number is not known to us.
Which number?
We had, Lordship, around 100.
The division bench says persons who have applied online and offline as on that date. Nothing more.
No.
How can you extend the date of the appointment?
Lordship, after the second advertisement, Lordship, even after the second advertisement, they were not able to apply because posts were not there. Computer was not accepting their application. That is why the approach before this court in 6331, Lordship. Thereafter, Lordship, court directed create post for them. So we de-reserve. After how many posts are to be de-reserved, Lordship? That number was not.
So that de-reservation is for them.
For them only, Lordship. So
then appoint them against that.
So we waited. So our wait was, let's see how many applications come. On the basis of, Lordship, number of applications, we created post.
You have created enough posts now.
Yes. Now
appoint them. We are recording that. What more is required?
Lordship, if we create post, Lordship, and hit merit position, the number of posts we are required to create is around 149, I think. We receive 149 application altogether. Now, in this 149 posts, there is our post, Lordship. As per the court's order, Lordship, as has been clarified in 6331, we are to consider the Assam TET candidates also. That is our understanding.
Sorry.
Lordship, we will that one.
You come to the, that is just a submission, recording of a
not submission, Lordship. 8.1 is a clarification.
No, that is
Lordship
a submission.
Lordship will see again. However, as clarified by this court, it is the observation of the court.
But this is a recording of submission.
Lordship will see again.
Mr. Mohanto, then again it comes, then the final conclusion of the court is from para 11.
Yes, but before that, Lordship, this observation is necessary.
Please don't pick up words. Please don't pick up paragraphs.
Lordship, and then Lordship will go back to original order, Lordship, page 53, page 101, page paragraph 53.
Correct.
So it has been clearly stated, Lordship, in paragraph 8.1, Lordship.
Okay, then why did you permit them to permit these 2 rounds of advertisement? This court did not require you. Come to page 144, last paragraph, last 2 lines of the 8.1.
8.1, last paragraph, Lordship.
Last line.
Last line.
And that eligible candidates include so-and-so,
And that eligible
and also
candidates
the
include
seated
the original applicants who are Assam
and who have applied in terms of the advertisement. Why did you go and extend it then?
No, that is Lordship will see. And that eligible candidates include the original applicants who are Assam TET and who applied pursuant to 2020 advertisement. Qualified candidates and also the seated qualified candidates who were petitioners before this court and they were yet to submit their application and who have applied in terms of the advertisement.
That is it. Only
So who are included, Lordship? Those assumpted candidates who applied pursuant to 2020.
who were they petitioners before this court in the two writ petitions, dismissed, went up to appeal, and who had applied in pursuance of 24/9/2020.
Who are they? Assumpted candidates?
Seated candidates.
Assumpted. Lordship, pursuant to deed advertisement, seated were
Both.
not available.
24/9/2020.
That is the first advertisement.
When they have also come in, Assumpted has come in, they are one. They are one homogeneous sector.
Lordship,
They are homogeneous. Let me clarify, bro. My understanding. They are homogeneous now. Now you had not appointed them, but you had appointed Assumpted because you said we don't want seated. Then the disputes arising was brought before this court. Matter goes up before the division bench. First round, DE, some observations. Second round is by SSA. Both this matter go up, issue goes up before the Supreme Court. Supreme Court said, nothing doing, judgment fine. So what is the judgment? Okay, that judgment they are also entitled.
Yes.
Now, if they are entitled, they'll be entitled according to their merit position.
Yes.
Now you publish advertisement, wherein you have already exhausted the vacancies for reserve, unreserved category.
Unreserved category? Yes.
EWS, you have exhausted. SC, ST, other categories are there. Even PWD is not there.
Yes.
So, 2 rounds of litigation again. First, 700 something, wherein DE candidate said do it in this manner. Same thing was again brought before this court by the present petitioners, SSA, saying that this has to be done. The final conclusion of this court is at para 14, page 148.
Yes, Lordship. That is what we have done.
We only want you to comply.
No, Lordship will, Lordship, I'm just clarifying one thing, Lordship. Pursuant to the first advertisement of 2020, they were not eligible. So not a single one of them applied.
We are not concerned with that. That
so on the day,
eligibility has now been given a rest even by the Supreme
So
Court.
on the day when the division bench passed its order, Lordship, not a single seated candidate were before us. Not a single application. Accordingly, we intimated through an
Where are those advertisements?
Advertisements are dates are mentioned here, Lordship. If Lordship comes to page 180. Page 180, Lordship. Lordship, may kindly see the judgments there, pursuant in compliance of judgments passed in so and so. And pursuant to last 4-5 lines, Lordship, pursuant to advertisement number so and so dated 24/9/2020. That is the first. Second one is 19/7/22.
What is this 19/7/22?
That is after the division bench. And third one is 16/7/2020.
What is this 16/7/25? Is it on record 16/7/25?
That
What
is
is that 16/7?
That is after 6331, Lordship.
What is that 16/7/25? You have a copy of that?
That has not been annexed, Lord.
Now come down 6.3. Candidates whose name appeared in the select list for the post of assistant teacher in lower primary schools and assistant teacher so and so.
Which paragraph, Lord?
That 180 itself.
180. Yes.
For document verification as on date and venue specified herein below.
Now, Lordship, these lists includes state CTAP as well as state TAP.
No. The selected seated candidates, however, are not required to. Now, what is the next step after this?
Lordship, now we are going to verify the documents of the Assam TET candidates, Lordship. I don't know how many of them will come, Lordship, because in the meantime, Lordship, there were recruitments. Probably some of them have already got regular recruitment. Just
you
because
don't know it because it is already over.
We don't know because in the not in our advertisement. Probably they have.
No. Got this 180. The date was 9/3.
Yes,
it's already over.
Over.
No. Yes, verification is over.
Over.
Verification.
So people have come.
And those persons who have been verified, Lordship, they are not before your Lordship. That is another issue.
We'll come. That is final hearing. We'll come. Today I'm trying to understand.
Lordship.
Now you have verified that.
Yes.
You have verified them. Now
Their-
what is
their
the next step?
verification is stated verification is over.
No, what is
After
the
this
next step?
verification, those who are selected from the seated category, they shall simply be handed over the appointment letter.
No, no, no. Here you say that the seated candidates are already selected.
Yes. Because the number is 149, I think.
No, what is this 342 then? Page 150. 151 to 179.
Lots of this list includes the 149 person applied from seated category as well as from the Assam TET
No,
category.
it is not there.
They were
It's
already
only seated.
list of shortlisted
All
applicants. of High
candidates
Court
are
Service.
seated.
On the High Court, no, applicants on High Court case related to qualifications or physical. Into TADA.
Unfortunately, this is only seated.
Only seated.
Lordship, I have to verify what is this document, Lordship.
It's all seated and we have 342. So they are selected candidates. They'll be appointed now.
No, these are applicants, Lordship.
No, it is
These are
shortlisted.
applicants. No, these are applicants pursuant to the second advertisement and the third advertisement. These are the applicants.
For verification. Document verification.
No, if these are seated, Lordship, they are verification. No, this is not the last verification. Lordship, these are the persons who, yes, now I understand, Lordship. These are the candidates,
people
Lordship. Lordship
who
will
had
have to see
applied.
the dates.
Who had applied?
Yes, who had applied and their verification is already over.
Over.
Lordship, may kindly see page 150. 150. Last paragraph. The verification process will be held with effect from 29 October 2025 to 1st November 2025. So far as the
150
seated
is
candidates are,
this is the list.
this is the list.
Now you come to 180.
Lordship. Along with this, Lordship, in the they should have they
You
should have
understand,
added
you
another
are
list,
in
Lordship.
the thick, you have much data. This code does not have data.
Yes,
Let this code collect data.
Just one point, Lordship. 1 point. Along with this, Lordship, one list was uploaded in the official website, Lordship, containing either the roll numbers or the names of the persons who are in that list, Lordship.
Selected list.
Yes. Selected list and the verification list.
Okay.
Probably it will be there.
Now come here. The candidates whose name appeared in the select list
Yes.
for the post of assistant teacher contractual
Yes.
in so and so,
Yes.
as notified in the website,
Yes.
are hereby requested to appear before the authority for document verification.
These are all selected candidates.
So,
Only verification part is
who are those seated selected candidates? Because you say selected seated candidates. So selected candidates are there now.
yes.
Where?
Lordship, that list was uploaded along with this notification.
Where do I get that?
Lordship,
list? Whether the petitioners are there?
Lordship of website of Lordship. As notified in the official website of Samagra Shiksha, that it was there, Lordship. It has not been downloaded. I'm appearing, Lordship.
So now tell me, we'll have it at 2, whether the names of the petitioners are there in the seat.
Definitely all the petitioners will
Then
not
that
be
is
there.
the end of the matter.
No, that is what I'm submitting, Lordship. Whether the meritorious assumpted candidates are to be considered or not, or they are to be given bye-bye, although you are below at the bottom merit list.
So what about the candidates who would otherwise be less meritorious than the seated candidates who have already been appointed? So do one thing.
No.
Assess their merit in relation to everything and thereafter make your appointments. We are passing that on.
That can be done, Lordship. If Lordship says that persons were appointed, even though they are below the seated candidates, if Lordship finds Lordship.
No, that is the order, not me finding. That is the division bench. That is the order.
In that situation, Lordship, if somebody is aggrieved, Lordship will definitely interfere.
Where?
If somebody is aggrieved.
I'm not on that. I'm only saying what was reiterated in para 14 and 15. That's all.
My only submission will be along with paragraph 14 and 15, Lordship will also read paragraph 8.1.
That we will not do. We will record your submission.
And Lordship will
KK
also.
Monta, we have spent enough time. KK Monta, Learned Senior Counsel, also heard Mr. You hear the order. Mr. P. Naik, Learned Additional Advocate General, appearing for the SSA respondents. The present writ petition has been instituted by the petitioners, alleging that the respondent authorities while proceeding to effect appointment in respect of seated candidates, have again brought into the fray Assam candidates who had cleared the Assam TET qualification and who had applied in pursuance to the advertisement dated 24/9/2020, thereby obliterating the chance of the seated candidates to secure appointment against the posts in question under SSA. The petitioners further project that the action now undertaken by the SSA authorities to also include the Assam TET qualified candidates in the fray, along with that of seated candidates, is in clear violation of the directions passed by this court by the division bench of this court wide order dated 19/7/2021 in writ appeal number 69/2021, as well as the directions passed by this court wide judgment and order dated 19/5/2025 in WPC number 6331/2022. Also, Mr. K.K. Mohanto, learned counsel for the petitioners, senior counsel appearing for the petitioners, by reiterating the facts noticed herein above, has submitted that the petitioners who are seated qualified candidates have an apprehension that in view of the inclusion of Assam TET candidates, their chances of recruitment against the posts available under SSA would now be diminished, and that would be in violation of the decisions of this court in the cases noticed herein above. Accordingly, he submits that the selection process now must be directed to be confined only to the seated candidates, as was directed by the division bench of this court and by this court in the earlier round of litigation. That is your case, Mr. Monto.
Yes.
Anything more?
You cannot bring in, open up the selection process for new candidates who were earlier not selected or left.
This is your case?
Yes.
Per contra, Mr. P. Nayak, learned counsel for the petitioner, learned counsel for the additional advocate general appearing for SSA, submits that in pursuance to the directions passed by the division bench in writ appeal number 69/2021, as well as the directions passed by the coordinate bench of this court in WPC number 6331/2022, notices were issued inviting applications from qualified seated candidates. Also, he submits that for the purpose of accommodating the seated candidates, around 149 posts were de-reserved, right?
Exact number will be lots of
Around 149 posts were de-reserved. He submits that the posts having been de-reserved, general category posts have been, reserve posts having been de-reserved, general category posts have been now created, which would be required to be filled up on the merit of the candidates in the fray. He submits that the seated candidates as well as the left out Assam TET candidates would be so considered. However, the Assam TET qualified candidates would be the candidates who had submitted their respective applications in pursuance to the original advertisement dated 24/9/2020. In view of the above, Mr. Nayak submits that the apprehension raised in the present writ petition by the petitioners is clearly unfounded. What? Anything more?
Paragraph 8.1. And secondly, Lordship, this Assam TET candidates, they applied against all those posts, Lordship, pursuant to advertisement of 2020.
That's
Now,
different.
if
We don't
any
know.
post is de-reserved, their rights,
তার উপরটা in the premises. Mr. Naik, in support of his submissions, a last paragraph for Agor in the above premises has referred to para 8.1 of the decision of the coordinate bench of this court in WPC number 6331/2022 and has submitted that the consideration now required to be made is to be extended to both CTET qualified candidates as well as Assam TET qualified candidates, and no discrimination in this matter can be meted out, provided the Assam TET candidates are the candidates who had applied originally in pursuance to the original advertisement dated 24/9/2020. I have considered the submissions made by the learned counsel for the parties. Also, issue notice, issue notice. The submissions made by the petitioners, by the learned counsel for the parties have been noticed. Also, this court finds that the issues raised by in the present writ petition was already considered by the division bench of this court in its decision. Dated 3/2/2021, passed in writ appeal number 24/2021. The said decision was reiterated by the division bench of this court in writ appeal number 69/2021, instituted by the petitioners and similarly other similarly situated persons.
One thing, my learned friend is referring to 8.1. That is the court has quoted from the division bench, which was subsequently corrected by the division bench.
I'll come
that part.
I'll come to that.
Yeah.
Also, the persons. Also, the directions passed by the division bench of this court in writ appeal number 24/so-and-so, was again revisited in an interlocutory application preferred by the petitioners in being IA bracketed C number 258/2021, wherein the observations made in para 54, more particularly, the stipulation therein that the appellants have the state TET qualification and other guidelines prescribed by NCT, and they fulfill the eligibility norms of the advertisement notice dated so-and-so, was substituted with the words other qualifications in the guidelines. Other qualifications in the guidelines. So thereafter, it is seen that the petitioners, these are the petitioners in 6331 or somebody else. 6331, who are the petitioners? You are the petitioners?
Somebody else.
Somebody else. A person similarly situated like the petitioners had approached this court, assailing a fresh notification of vacancies notified by the SSA authorities. The said writ petition was disposed of by the coordinate bench of this court by judgment and order dated 19/5/2025 by issuing the following directions. Paragraph 148, paragraph 14, 15. We'll continue at 2.
For item number 19, Assam University matter, just now we got the affidavit. I just want to take some instruction from my client. Can it be tomorrow?
No.
Lordship is taking up today.
If today or after 2 weeks, there is no space in between.
Then
After
today
2 weeks.
at 2. After
2, no, we have fixed some matter. You can come by 3.
3. Obliged.
Remind. Where is Mr. Naik? Mr. Montoff, one question, shall we dispose of the writ petition
Yes,
or
I think
dispose of? What we have done, Mr. Naik, Mr. Montoff, I have dictated the order now. What we have done is we have noticed the entire position as obtaining in the matter. And we have also noted that you are having an apprehension because of the introduction of the Assam TET candidates. Your chances for recruitment may be diminished.
Yeah.
But we have said that the respondent authorities are bound to follow the division bench order and para 14 and 15 of the coordinate bench order passed by this court. And accordingly, we have directed that while considering the recruitment against the remaining vacancies out of the vacancies advertised by 24/9/2020, the respondent authorities shall strictly comply with the provisions of para 14 and 15 of the coordinate bench decision and thereafter proceed in the matter. We have also provided that in the event any of the seated candidate feels aggrieved, he is at liberty to come back.
Just one clarification, Lordship. The list is already there. It has been uploaded. Now there is no question of apprehension. If they are there. If you are not there, not there.
So select list is already up.
149 reel has already been uploaded.
So if those persons who are there in 149, they will be appointed.
I'm not going to say that. Two seated candidate, I mean, the number of seated candidates who are selected, they are going to be appointed in any case.
No.
The seated candidates who are there in the select list, they are going to be appointed. There is no question of verification.
So around 149 seated candidates will be appointed.
Yes. Out of
Are your names there in the? You have not made any statement to that
There is
effect.
no question of apprehension, Lordship. The list is already there, uploaded in the public domain, Lordship.
We have only said this much.
No. What I'm submitting, Lordship, as there is no question of apprehension, they have to silence that list, Lordship.
Okay, they have come up before us. We have not said anything. We have only said follow para 14 and 15. That's all.
Yes.
Of the earlier decision. That's all. That you can, because you have not, I even said that there is no challenge to that order.
Because otherwise, Lordship, those who are selected, Lordship, even if it is stopped, Lordship, at this.
I'm not stopping.
Yes.
I'm only saying that you proceed with the selection in compliance with para 14 and 15 of the coordinate bench's decision. That much only.
That is always binding on them.
Binding on them. I've
It is
just
always
reiterated
binding.
that.
Only thing is, Lordship can be pleased to add that what they say now, this recruitment means to fill up this post.
I have said that the remaining posts are being filled up and the remaining posts will be filled up because the procedure is already laid down by the division bench and by the coordinate bench. They will not deviate therefrom. That much only.
That is good. That is because first, without considering the case of the seated candidates, they cannot go ahead.
Mr. Mohanto, that is already there. Why should I again pass a direction? It's already there. I have just said you don't deviate from that.
Well, because what I am apprehending, they may interpret it somewhere else now.
I have not given them that scope. I have only said 14 and 15 you are bound to follow.
Yes.
We'll dispose it of.
Lordship has not interfered the list we have already.
No, nothing.
If somebody is agreed, they will.
I have even provided for that.
But if this clause, because in this impugn order, clause
You
B,
see the clause C there.
clause
That
B,
last. Because Mr. Monta, if they go beyond, because now they have not done it, so we don't know exactly what they are. It's a it's in a fluid stage now. That fluid stage has already been directed by this court, coordinate bench of this court, division bench, that you proceed in east direction. If they go in west direction, come back. We are here.
Like if they have published the list, yeah, that is the final list they want to
Why
say.
are you creating so much of confusion about this poor kids?
That is what, well, if they're.
Because
if
Lordship,
multi-
I have seen the marks obtained by the state candidates. They're far, far ahead, Lordship.
No, but the persons you have appointed, para 15 also says that you will have to compare with them also.
No, in that situation, Lordship, somebody, they are already appointed. And one most important thing, Lordship, I'm telling your Lordship, these posts are contractual posts. I don't know whether next year this post will remain or not. These are not permanent posts, Lordship.
Mr.
We are not for that.
Nayak, even if for a year these people can be appointed, a family will be rescued.
On the other hand, Lordship, these are the same candidates who applied for DE as well as under SSA, Lordship. In DE, Lordship, appointments have already been done.
Seated candidates have also come in.
Yes, same candidates. They were candidates in the DE application.
Why do you come
While
here?
they'll come for contract.
Why do you come for contractual? They are already absorbed.
See, my hands are tied. There is a division bench judgment. There is a coordinate bench judgment, well reasoned.
Yes.
Well reasoned, taking into consideration everything. I have only said, my hands are tied. I can go neither this side nor that side. They have come before me with a conclusion. I said, okay, if that is your apprehension, we are directing state, don't violate para 14 and 15. That's all. Disposed of.
Because they otherwise cannot bring in any fresh candidate, even from Assam TET, because that was.
Oh, if they do that, Mr. Mohanto, we are here 24/7. You can come. Even on Saturdays, we are here. You come back.
No, that is, again, these people
They are
will
not
be brought
fresh
again
candidates.
and
They are
again.
applicants pursuant to 2020 advertisement itself.
So they had to wait till
Because see,
now.
what I liked about them is that they had given you seated candidates 2 opportunities to come in, whereas the Assam TET stopped at 2020.
Just one point, that Lordship has seen that list of 342. Those were applicants, Lordship. In response to all the advertisements and in response to the order passed by the Honorable Court, 342 applications we received
Now,
from the
total
seated candidates.
342 are there.
Out of 342, Lordship, we found 142 eligible because some candidates were there who were not even petitioners before this Honorable Court. And court directed us only to consider the petitioners. So ultimately, we received a figure of 149. Accordingly, we reserved or created 149 numbers of posts. Then we created the merit list.
A point. 149 people getting employment, nothing like it. We are
I'm
happy.
not sure, Lordship, that 149 will get.
Oh,
I don't know how many of
140
them will get because
140.
it's an advertisement of 2020. I don't know how many of them.
We are
appeared
ready for
before
the next
verification.
round by Mr. Mohanto.
Most of them probably in the meantime has got some appointment somewhere else.
Maybe.
Therefore,
But these petitioners have not got, otherwise they will not be
before this court.
here.
Why?
No, they're sure because their list is in the public domain, Lordship. They are sure that their names were not there. That is why they are. So there is no question of apprehension.
And if
It's already there.
well, then
Okay, shall I add one more line?
Yes.
That in the event the petitioners are not favored with an appointment, you will issue to them the reason.
No, I'm not saying that. I'm saying the list of 149 has already been uploaded.
But be that as it may,
So if they are
out
there,
of the 342, the persons who have been left out, who will not get appointment, there will be a reason for that. Maybe 8.1, maybe something else, maybe the language, maybe something. Shall we also incorporate that you will issue to them at the time of the final appointment order, communication?
No, final select is already there.
The others who have been left out, you issue a reason to them why they have been left out. So next time we find it convenient to consider the matter. I'll add that line.
If they approach the authority, why my name is not there in the 149?
Okay.
Definitely we are bound to give them reason.
Okay, we'll do that. We'll do that. We'll make a provision for them.
But that is my ultimate submission is that there is no question of apprehension.
Mr. Nayak, I have not caused any prejudice to you. I have only said 14 and 15.
So they should notice, let them come up with their application. Also,
no, we have only said follow 14 and 15. Don't deviate therefrom. That much only. Nothing more, nothing less.
Yes.
Then I can't do anything less than that. If I do more than that, fine, different question. But I can't do anything less than that. I'll have to follow that.
Lordship,
Okay.
because I am trying to justify why the stated candidate. were
Over that
considered.
material, that stage has not come. That will come in the next round of litigation.
Lordship, I understand.
And we'll provide for that. In the event anybody is left out, they will communicate to you the reason. So that Mr. Monto, next time you can come armed with that. And we are also in a position to
Look into it, consider it.
appreciate
The
that.
petitioners.
Petitioners.
They should inform us. We need not have to go to them because there is
Oh.
already order.
Oh, you are a little bit more free than them. So you approach. You are a little bit more free. Means your candidates are free. They are very busy.
They are under the direction of this honorable court already. Right?
And I have done nothing other than reiterate that direction.
That is why they are under the obligation of those orders itself. And since then they are not working. Therefore, my responsible submission is
And
just
all the
communicate
orders
if they find
passed
that
by
because
this
of this
court are
or a general
well-reasoned
order.
orders upheld by the Supreme Court.
Yes, yes.
Okay, next.
Obliged.
Because this notification, Lordship has not interfered.
I don't know how late, but I'll upload it today only.
Yes.
How late, I don't know. 8:30 maybe.
Deeply.
I'll upload it, but there will be some rounds of correction after this.
Lordship.
Even?
Lord, this is peculiar case. 2 times they approached the Honorable.
We have noticed your preliminary objection. We'll consider it. Let us hear Mr. Decca first.
I am submitting on behalf of Mr. TK here, Lordship. Here, Lordship, the petitioner is agreed by the impugn order, Lordship, 18/7/2000.
Page?
It starts from page 147. Party portion 148. It starts the.
Where is the better copy?
Lordship, today I am very interested with this.
No, you have brought it on record. Yes, page 204.
Yes. 204, it starts from 204, 205.
Yes, what do you have to say?
Director says that the claim of the page 202, Lordship, the second paragraph from bottom, Lordship, whereas the claim of the petitioner for provincialization of services under Act 2017 has been examined and enrollment position of the school is verified, the data, DICE data, for the year 2016, 17, 17, 18, wherein it is found to be 87, 67. Now, decision. In view of the above, as per clause 3(1)(11) of the Provincialization Act of 2017, the school of the petitioner is eligible for provincialization of service of 3 teachers of the school. On the other hand, service of 6 number of teachers are already provincialized during 2013 as per Act of 2011, and the name of the petitioner so-and-so is additional to the 6 number of so-and-so school. Hence, claim for of the petitioner for provincial service cannot be considered under the Provincial Act of 2007.
What is your prayer finally, basically?
To set aside this order.
Only that much?
Lordship.
Anything else?
Yes, Lordship. And allow him to continue, Lordship.
Allow you to continue in what terms?
Because in the earlier, that was
set aside.
Set aside. But
So
here,
your
Lordship,
cases can be considered only under
my
the
basic grievance is that, Lordship, although there is a direction to consider the case
under
of
the 2017
Act, but
you will have to fulfill
director,
the conditions of
but
the
director, Lordship, while Lordship issuing this order, Lordship, he has not go through the process for provincialization because it is a 3-tier scrutiny committee. That is not followed.
Okay, show me that your school has more than 100, 300, 400 students. That much number of posts have to be.
No, they consider only for 2016 and 17. The order issued in the year 2019 or 2024. So they have to consider up to 2023. That is not considered. That is the second aspect.
That is no consideration.
And the first consequence is also is a 3-tier scrutiny committee. Director is not the final authority. And there is also no
Anything more?
Lordship.
Anything more?
Yes, Lordship. But that was Lordship, in fact, not brought in the record. So before being appointment, it is admitted fact is that the respondent number 9, he is an additional teacher. Now the.
That has been gone into by this court.
Yes, Lordship, but the authority, this order was not.
That we cannot. We cannot reopen now. That order, that thing has been settled by the judgment and order dated 19/7/2018.
But it is up to the school authority before being appointment, Lordship, they have to
that
take
you
in
don't
the
argue.
approval.
That we will
Approval
not
from
do.
the director.
That we will not.
That was not taken into consideration, Lordship, number one. But the first consideration, they have to follow the provision or procedure followed by the act. That is not followed, apparently, Lordship.
You show me from your materials that your school has more than 600 students, 400 students.
You know, so
100 means one.
I have to take instruction
No,
to the Lordship.
sorry.
I mean,
If that is the ground, that ought to have been in the writ petition. We cannot permit you.
so apparently from the order itself shows, Lordship, simply say this dias data also it reflects for 2 years, 86 and 87. In fact, Lordship, he draws salary also under 2011 Act.
And that was set aside by this
Set
court.
aside, Lordship, I am not making any submission on that, Lordship.
You have not filed
But
an
so-
appeal against that.
But so far, the provincial is under this 2017 Act. There is no specific direction to the director, you take decision. They have to follow the procedure. That is not followed. That is what my case, Lordship.
Procedure would be
No, had
once
the- had
you
the
are found to
authority-
be eligible.
Had the authority, Lordship, taken into consideration the report from the field, Lordship, that was not considered. That is not considered, Lordship. And they have to take the records of that procedure of section 13. That is not followed.
Okay. Anything more?
But the vital document is not brought before this court, Lordship.
That we
already.
cannot go into.
Some mistake on by the council, Lordship.
That we can't help.
So that aspect, so that should be remand back the matter, Lordship, and let it follow the procedure.
We are not
But
remanding.
they will get the Lordship up to their instruction.
We are finally taking a call here.
But so far, me, Lordship, to get instruction from the school, Lordship, it is very difficult. Now, up to the authority, it is very easy, Lordship.
Authority has given a figure, you have not disputed
No,
that in your
but this
petition.
school, Lordship, 2016, they only considered 16 and
Oh,
17.
where is your statement that this figure is wrong?
I'm saying that, so this.
Mr. Decker, bring on record a statement that this is not. Then I'll ask them. Why should I ask them otherwise? You have accepted that position. Show me from your writ petition or any pleading that this figure of students, number of students is wrong.
Let me have some volume. I will bring the records. I will find a register.
Mr. Decker, that was the
today I am
first point.
appearing.
That was, you appear, you don't appear, I don't know. But that was the first point in the writ
I am
petition that
submitting
ought to
for
have
the
been.
fault of the council, Lordship, the petitioner should not suffer.
Sometimes
That's
we
right.
can't help it. It's not the fault. It's the facts.
The fault, the vital document that was not brought into notice, Lordship, the court. That was that if had the Lordship placed this document.
Okay, yes, Mr.
My lord, first thing is, my lord, that there was writ petition.
Writ appeal.
That was dismissed.
Writ appeal.
Writ appeal was filed, that was also dismissed.
Dismissed.
But observation was there that he may take shelter of section 17 of the 2017 Act.
Hmm.
Now he also filed contempt case and that is also closed.
Hmm.
So what more?
Nothing more. And the 2017 consideration, he has not brought on record any material.
We are not against them. If he gets as per 2017 Act, we have no objection. But he cannot run after me. When the matter has reached its finality by the division bench of this Honorable High Court.
Only here is my.
Show me that the number of students in the school is to be considered from a particular date as per the Act of 2007.
The preceding 3 years, Lordship, from there. Minimum 3 years, consecutive 3 years.
Show me.
It isn't problem. Sorry, Lordship.
No problem. This is a book of the court, not my personal book. It's in the, just after 2 acts. Just remove a few pages from
2017, Lordship.
top.
Assam Integration 2020.
Down below, third or fourth act.
It is non-teaching.
Before that, non-teaching.
Before that, Lordship, it is 2020. Yes,
Then
yes,
after
page 99. It's specifically mentioned as for last 3 consecutive year loads. After some time, so let me go to the after 5 minutes.
Yes, Mr. Roy.
Yes.
Any development?
Yes, my lord, made a query on the last occasion. I wanted an instruction, definite instruction as to why the proposal could not be. My lord, I received a written because they have given, I wanted a written instruction from them. They had some, because of the circular issued by the DME, my lord, lordship will go through that.
DME?
DHE, I'm sorry, Did Higher Education. The circular I have annexed, my lord. They said one certificate, non-liability certificate has to issue. We are finding it difficult to issue the non-liability because ultimately it is the DHE, my lord, Director of Higher Education, who is to sanction. The circular I have annexed, my lord. It is at, the lordship will find the circular dated 24 and the serial number 22, the last page. This is the requirement. So this certificate we cannot issue because of this, my lord, and let the government, my lord, the DHE take a decision on this. We have already written to the government. If
How was this pension done without a
pension, my lord,
Pension also
pension,
requires
this
some
circular is meant for.
Huh?
This circular is meant for leave encashment.
Forget it. For the
Pension,
pension
in fact,
also there is.
my lord, pension
Page?
Page 30.
Of
My
the
lord,
petition.
pension, my lord, it was done. I mean, at the time when he was the principal.
No.
Pension is different, my lord,
When did you
because
retire?
My lord. 3011, my lord, 24.
3011.
Yes.
Huh?
Yes, lordship.
This is of 19820. You were there. So you managed them.
so, my lord,
It
let
was
the
given by the
DHE
president.
take a decision.
Even as it may. What is the stage of the inquiry? Audit?
My lord, we have sent, forwarded to the government.
Mr. D. Upamanyu, Learned Counsel for the Learned Standing Council, Higher Education Department on the next date of listing shall apprise this court as to when the pension and pensionary benefits have been released to the petitioner on the basis of a non-liability certificate submitted by the college authorities as to why further non-liability certificate is being required by the Director of Higher Education for release of the leave encashment benefits of the petition. That's why they say that because of you give him a copy also.
Yes, yes.
Give him a copy.
I just now I'll give him.
Regarding DIS, it will be paid pension.
That you give pay, but this one you see, leave encashment. There is a decision as to what exactly leave encashment means. Means that it cannot be withheld under any circumstance. This, so the night I was searching, I wrote it down somewhere, I forgot. Just check up. Huh?
Virtually, it's a payable order.
Yes.
It's a payable order. You cannot do it.
That's
Just get me that.
Date, my lord.
Raised it to list this matter again on 33/2024. 33/2024.
Lordship, here, but area enhanced subsistence allowance for a particular period from
Where are you now?
Still under suspension, my lord.
You are enjoying your suspension. You are enjoying your suspension. What are you doing?
Paid poor employee, my lord.
So what are you doing?
Nothing, my lord.
Huh? You are enjoying your suspension. It's a paid leave. You have not challenged your suspension. Why? Why? Don't want to work.
No, no, my lord, I have advised my client, he's
Suspension from 2018. And what happened to the criminal case?
nothing, my lord. Same stage. my
And you are, what is the allegation against you in the criminal case? Not there in the writ petition. What is the allegation?
lord. My lord,
It's not there, Mr. Counsel.
it's not.
Even the sections are not there. Yes, why should we entertain your this application? You are enjoying paid holiday, public money.
It is the lapse on the part of the
Yes, what is
department.
this suspension being prolonged like this? Why? Why are you paying him? Is it that bad an employee that he cannot be brought in? What is the allegation against him? Get me that tomorrow. Mr. Sharma, Learned, Standing Counsel, Elementary Education Department, on the next date of listing, shall apprise this court about the allegations leveled against the petitioner in the criminal proceedings pending against him in Patharkandi PS case number 413/2018. Registered to list this matter again on 18/3/2026. Get me that.
Obligation.
Yes, Mr. Monto, you have any other matter?
Yeah. But still,
Huh?
lot of the learned councils of the state.
Which
it
one?
will not be taken up.
Top of the list matter.
Top of the list matter, that one, my lord,
Oh, that matter.
yes.
Who was to oppose you here?
Mr. K. Gogoi, Coast of
Where is
Gogoi.
Mr. Gugui?
Last two occasions also they have short time.
You go have a cup of tea and come back.
Lord,
Or we'll have it on some other day. How long will you wait?
Two occasions.
that's my like uncertainty on their
No,
part.
no, no.
That's the difficulty. I can wait, otherwise no issue. But then on the last two occasions, at the same ground,
Same thing, same,
Mr. Vasagi,
I remember.
I can wait, but then whether they will be available
We'll
or
wait
not.
for some time, then we'll hear you.
Yes.
Yes, Mr. Roy, what are you waiting for?
12, my lord.
Yeah, the opposite party is here?
Yes, sir.
Yes. Oh, that transfer.
Yes, sir. The junior is was here. 1 minute, my lord. I'm sorry, my lord, but he's here always.
There was one more matter today, Hindi teacher, Karbi Anglong.
My lord.
Which is that item?
That is 32.
32.
My lord, see the impugned order, my lord. At page, my lord, 32,
Mr. Roy,
my lord.
before we go to that, give me your service particulars. Your service particulars.
My service particulars, yes. My lordship may see page 31, my lord. I am number 5 in the graduate cadre. I am the senior most teacher, my lord. Joined in the year 1992.
Page?
Page 31, my lord.
You are Rekha Mani Bora. Where is the other lady?
Other lady is in a different school.
Or she has come here?
She is on promotion. She had come to
My
Your
my
school.
school, my lord.
There are two schools here.
Yes.
One is
Kildup High School,
and other is
Longleat High School.
Longleat High School.
So she from Longleat
Came to your school
in my
and the headmaster of your school went there.
went there, my lord.
Now show me that. This is seniority wise, school wise.
Initially, my lord, they are promotion is being made as per school-wise seniority. Then they have adopted from 26 to 2024 is a district-wise selection committee.
Now, where is that impugned order?
Impugned order is page 32, my lord.
So when the order was issued,
Yes.
it was not a
No,
district-wise thing.
No, it was school-wise seniority, and she being transferred, and my school principal being headmaster being transferred to other school.
because the next promotion I would get it, my lord, if
And he is retiring, the other
if
person.
retiring. But for that reason, my lord, they have issued a decision, lordship, I will bring it. Lordship may see page 44.
40?
In their affidavit, my lord.
Hmm.
With reference to the subject matter, I am directed to inform you that in respect of schools provincialized in the year 2013, the graduate teacher of these schools have
That is
not
why I wanted your particulars.
Yeah.
You were provincialized
in 2013.
13. So 10 years
10 years.
therefrom.
10 years.
They say 2012 December, we will say 2012 December. Now you are not eligible on the date the private respondent number 5 was considered for promotion. You are not.
No, but she's from the different school.
Yes.
Yes.
She was considered there.
There.
What is the bar in transferring her to this school at that point of time?
No, because this, as per this policy, because as the school was seniority has been followed, so they didn't want to disturb the school. That's why the decision is there that this will not apply to them, my lord. Lordship may read it further, my lord. Page 44, my lord.
Hmm.
With reference to the subject cited above, I am directed to inform you that in respect of school provincialized in the year 2013, the graduate teacher of these schools have not completed.
No, this is a decision of the government, Assam.
Yes.
That may not be applicable to
That
the
is,
Karbi Anglong.
that is their document, my lord.
No, this
They
is
have a
not
next.
additional secretary. This is secondary education department.
Additional Secretary Education Department.
This is education. This
They-
is not,
they-
because
they-
that's a transferred subject.
They are relying on this document, my lord. They want to say by this document we have been out. But I mean to say that this document says that the school which is provisionalized.
Well, there was a vacancy in that school also, Longneet school also.
Yes. Now also there.
Yes, Mr.
Now also there, my lord.
My lord, petitioner is required to complete as per rule 14, my lord, 10 years continuous service.
No
for-
issue on that.
Not,
No
my-
issue on
And the petitioner at that
No
time,
issue on that.
my lord, he has not completed the 10 years of service
None.
and death. My lord.
But you adopted
Now, my lord,
the
we have
district-wise
adopted,
concept
my lord,
only in the year 2024.
my lord, lordship will look into our additional affidavit. We have 5. We have now prepared the district-wise seniority list, my lord. The position of the petitioner in the district-wise seniority list is at now, my lord, serial number 31, my lord. And my lord, promotion is required to be made as part of, my lord, as per our policy also. And the qualification also we have adopted, my lord, the state of Assam policy, my lord.
Okay, fine.
So, my lord, the position now, my lord, the position
No,
of
this
the,
is subsequent.
my lord, subsequent, my lord,
That is in the, even the writ petition is dismissed.
my lord, my lord,
This will come into being.
my lord,
Now tell me,
my lord,
you adopted you have your own independent action you
my
can
lord,
do.
my lord.
Now, you did not have a district-wise thing
Seniority at that
before,
time, my
before 2024.
lord.
Now, why the petitioner, the lady, was not promoted in Longleaf?
Now,
She was not promoted in Longleaf.
my lord, the
unfortunately.
petitioner, my lord, petitioner,
Respondent, sorry.
my respondent, respondent was promoted in Longleat High School.
Show me from the order.
My lord, in our affidavit, my lord, minutes of the DPC meeting held on 24/3/2022 at
Page 46. Let us read that.
The meeting of the Department of Promotion was presided so and so. The chairperson of the DPC, the chairperson becomes the member so and so. Schools, Karbi Anglong Depot on the matter of promotion with transfer.
This is the question. Why?
Which from the present post of assistant teacher graduate of Longleat High School to the next higher rank of headmaster and to be transferred to Kildev High School in the same capacity.
So where is that promotion to Longneet? Where is the vacancy of Longneet being
My lord,
considered?
at that time, my lord, Longleat High School vacancy.
Maybe, but here you have not promoted her. You have directly transferred her.
No, my lord. On placement of the proposal, the committee verified all the documents. On verification, the committee found that so and so was appointed as assistant teacher graduate.
Is
My daughter,
eligible for promotion to the post of headmaster of high school.
she has the qualification of, she is the senior most graduate teacher of Longleat High School as per the graduation list of so and so. And he has completed 17 years, 4 months, 20 days continuous service on so and so date. She has the requisite qualification eligible for promotion to the postmaster or headmaster of high school. Nothing adverse report so and so. As such, the committee at trade by decided to recommend the promotion of.
I'm sorry, this is not a case for promotion in Longneet. That vacancy was never considered. The vacancy that was considered was Kridap. You transfer her. The proposal is you promoted her to the rank of headmaster,
My lord.
not rank of headmaster in Longnit.
My lord, that,
I would have understood that you promoted her to Longnit and then you transferred her out.
my lord, that is
Not
our
this.
case. That is our case, my lord.
But that is not reflected from your records.
My lord,
The inspector puts up a proposal
my lord.
for transfer before promotion. How can that be?
My lord, lordship, at that point, my lord, whether at that time Longnit High School headmaster was vacant or not, my lord,
It
that
is
is the
vacant.
point, my lord.
Otherwise, the person Durgesa Soikia could not have gone there. It is vacant. That is accepted.
My
But
lord.
you never put up a proposal per se for promotion to post A.
My lord,
You put up a promotion to the rank of A and
lord.
transfer to B.
my lord,
That cannot
my
be.
lord,
Justify that.
my lord. My lord, written argument was there, my lord, earlier, my lord.
Forget the written
My-
argument. I am only stuck here.
My lord. My lord, that point, my lord, whether that at that point of time, Longnit High School headmaster was vacant or
It
not.
was vacant. We hold it that it is vacant. I give you that. It is vacant. But
My
the
lord,
promotion would be school-wise.
school, at that time,
And
school-wise.
it cannot be
My lord,
that you promote her to the rank of headmaster and transfer her.
my lord,
Promote her as headmaster Longnit,
my lord,
thereafter transfer her, I
my
can
lord.
understand.
my lord.
The order at page 32 does not promote her as headmaster Longnit.
If you, lordship, to clarify that, my lord, high school is promoted to
is
the
required.
next
It
footcase
cannot
headmaster,
be.
transfer to headmaster of
That
Kilabel.
clarification, Mr. Chutia, is available in your page 46. The proposal was promote her as headmaster and transfer her to Kilda.
My lord.
Yes, Mr.
My lord, when,
Chakraborty,
my lord,
you are appearing for the...
my lord.
Ah. What do you have to say? Where is your promotion order as headmaster Longnit? It is school-wise.
Lordship.
Lordship, even then, Lordship, I can be promoted at Longleat also.
Where? Where is
The
that
post was
order?
vacant. Otherwise, how could the Durgesa Sarkia was interchanged?
That's why
with that?
it is a
Even then, the case remains the same. There is a petitioner cannot be
that
promoted.
is different. But tell me, where is your promotion order to Longnit? Your promotion order consideration is promote you to headmaster and transfer you to Longnit.
Followed by.
No, it doesn't say. It
Yes.
does not say.
The
Is hereby promoted with transfer to the act as so and so. So you're basically promotional post is filled up high school, not Longnit.
Lordship, the promotion preceded, then thereafter the transfers comes.
No,
Lordship.
the proposal for the promotion, consider.
The record be produced by
It's
that.
there, page 46.
What, 40?
My notes.
That part has not been annexed to the affidavit provided to me, Lordship.
Mr.
have only
Chutia
the
can give you the copy.
In any case, my case is, Lordship, that she was not eligible on the day I had been transferred. How
That
can
is different thing.
no, sir,
That
unless
is
she has a
different.
locus standi to challenge my
That is
promotion.
different because Mr.
Doesn't have the
Mr.
locus standi to
Chakraborty-
challenge my promotion.
Mr. Chakraborty,
Lordship.
the issue here is the government itself had taken a decision which Mr. Chutia is relying. Wherever the colleges are provincialized, teachers have not completed 10 years, those posts would be kept out of the purview of selection. So, killed up could not have been brought within this.
No, Lord,
And that is the reason why this via method was utilized.
Lordship, on the because the post was created only from 1/1/2013.
You come to page 46. Discuss the proposal of the inspector of schools on the matter of promotion with transfer from the present post of so and so to the present post of assistant teacher graduate to the next higher rank of headmaster and to be transferred to Kildup.
In the same capacity.
Ah.
This minutes are to have been challenged, Lordship. This has not been challenged. Because this is the
These are
foundation.
minutes which are
This is
there.
the foundation.
No, these are minutes which are there with Mr. Chutia. The petitioner cannot get. Now, this is reflected in the order. He has challenged the order. So this automatically gets, I'm thankful to Mr. Chutia that he is fair in bringing this on record.
In any case, Lordship, being not eligible, whether she can challenge one.
Yes, because her right has been, because she, page 44, order. Decision of the government. Should be kept out of the purview of promotion of regular headmasters, which is under process till 31/12/2022 and until further orders. Anything more?
This is a policy decision, whether that can be given any right, Lordship.
No, it's a policy decision. It's that they say exclude, now you bring it, include, that cannot be. If that is the decision, that is the decision.
But Lordship, I'll be relying to one decision, Lordship, that the senior to look at only from the date the one who received graduate skill.
Fine, no issue on that. No issue. 1/1/2013. Before that, Mr. Roy brings in 100 judgments also, he will not get it.
Lordship.
But I even admit to the fact Mr. Roy is not eligible. But page 44 and the proposal which was there, that was not a proposal for promotion to Longnit.
That
It
was
was
not,
the promotion
that was
to,
not his case also, not a pleading also that.
you come to page 32. Mr. Roy may not have pleaded, but we interpret it in that manner. In so-and-so issued by so-and-so and the public so-and-so is hereby promoted to the next higher rank of full-fledged headmaster with transfer to act as headmaster at Kridap. So where did you join as Longnit? You never joined as Longnit. The beauty is that you ought to have joined as Longnit headmaster, then you transfer, I would have nothing.
Because transfer is, there is no but interest for transfer.
But the transfer will not be from assistant teacher to headmaster.
No,
It will-
promotion
Where did you assume that post on promotion? You should have
Use
assumed
the
that-
record to that regard. Lordship.
This is enough. We don't want any records.
Because promotion preceded, then thereafter the transfer.
Mr. Chakraborty, what is promotion? Promotion means assumption of charge of a higher post. In the context of the matter,
There is a
as was
vacancy. There is a vacancy.
that vacancy in Longnit exists. So you can be considered against that. You join against that post.
Cleared up, long lead also vacancy existed. Otherwise, this Durgesha Sega will not have been accommodated.
Mr. Chakraborty, you get promoted, you join there. Thereafter, wherever they want to take you, they'll take you. Now you were never considered in terms of the materials available on record against Longnit.
Because vacancy was existing in the Lordship Longleat also.
Show me, when did you assume the charge of the post of Longnit?
Longleat. I have to take instruction to that.
Here, you never assume charge of post of Longnit. Your affidavit is on record.
Lordship, promotion with then subsequent transfer is no bar, Lordship.
Oh, it is not subsequent. That is why my case. It's not subsequent, it's together. You have filed an affidavit?
Lordship, I filed it.
Bobby, okay.
I can take the instruction of whether the private husband assume the search in Longleat High School or not. Kind of. I can take the telephonic instruction also myself. That's very easy. Our affidavit will clarify that.
Come to para 2 of your affidavit, page 54.
Train the mindset you from. Teacher.
Now, when did you assume that charge? You have not even disclosed anything with regard. We are not going to promote Mr. Roy, but we will only interfere with your illegal promotion.
This affidavit says that I was promoted for Longleat.
But when did you assume that charge?
Let me take instruction to that, Lordship.
When?
2 days time, Lordship.
That much? I'll forget otherwise.
Issue is very simple otherwise.
It is very simple. Just show me that you assume charge of the post office. I'll dismiss the writ.
Lordship. My learned friend said that he can take telephonic instruction.
No, we want Mr. Chakraborty to take.
Lordship will take
Chakraborty may not have the
only thing is my lord.
wherewithal like Mr. Chutia has in KAC.
Well, only thing is my lord, Lordship keep it as a partner because we are fighting for my
Oh,
last
nothing is going to, even if we allow, I interfere, I'm not going to promote you.
I don't want, but
You won't
I
get
want
it.
justice.
You won't get it.
Uh,
And then we will have to see whether the continuance of so-and-so, now, we may even ask her to be transferred out from that post.
Yes.
So that the incumbents in, now it's the district level.
Yes.
So no difference. End result might be 0, but we want to know how this promotion was.
Only pleasure you will get.
Only sadistic pleasure, nothing more. Heard the learning council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on Thursday. I sleep.
Okay. Thursday, my lord.
Yes, who is for the government? The higher education does not seem to. Yes, Mr. You can make your submission.
I pray for some, I'm just entering appearance today on behalf of respondent number 3.
Fine. Your stand is already on record. We don't require a stand from you.
You have challenged this office memorandum.
Now we have got it.
Yes.
Yes, who is appearing for the education, higher education? Yes, Mr. Yes, Mr. Kotogi, you can make yourself.
Yes,
In this case, I have received certain instruction, my lord.
Okay, fine.
If my lord allows, then we will file affidavit.
You can place that instruction on record.
But I can hear the
Yes. You can take it. Yes. This is not your own decision. This is a decision which is contended that you are following the UGC circular. UGC itself says that the circular, that the PhD degrees issued earlier than 25-26 will not be brought within the purview, will be recognized. How can you de-recognize a degree which the UGC recognized?
My lord, what was the contention behind issuing this OM was that if my lord sees page number 41, the public notice issued by the UGC, they say that the second paragraph, my lord, after analyzing.
I have got it.
Yes, ma'am. Examining.
Very, very serious.
Submitted by the university, the standing committee was found that 3 universities did not follow. It was the past act of those universities which the UGC has find that.
Okay.
My lord.
Where is that RTI reply?
RTI reply, you also will find that.
Come to page 45.
Yes, I have seen that. 6.
45, 46 is the original.
So UGC says that the degrees that are issued prior to the public notice will not be brought in the purview. How can you go a step over UGC? If you have brought on record materials to demonstrate that Singhania University has not been following the procedure, We know of the period when Mr.
Yes.
Kotogi's client was doing, fine, no issue. You lay that material, but you have not said, you have followed only the UGC notification. Madam, that is the case.
As per the writ
We did not permit you to, did we obstruct you from getting?
issue to put the
On the prayer of Dr. P. Agarwal, learned Planning Council UGC raised it to list this matter again on 24/3/2026 for further hearing. Ms. Agarwal, on the next date of listing, shall clarify as to whether the RTI reply as brought on record by the petitioner as annexure
And there's annexure 13, madam.
Annexure 13 to the writ petition was issued by the UGC authorities. She shall also clarify as to whether the public notice dated 16/1/2025 would have an effect of also rendering the degrees issued by the Singhania University prior to 16/1/2025 to also be not would also to be also not would kill his degrees issued by the Singhania University before 25 to also be covered by the bar brought on record by the bar introduced by the public notice dated 16/1/2025, and the said degrees would also have to be treated to have been issued by a university not recognized by UGC. 23rd. 24th.
24th March.
24th March. Interest not paid.
Not paid, madam.
Cost amount paid. Where is the interest part? Here?
Page 14, my lord.
14.
My lord, page 14. If the entire due amount are not paid within the next 3 months, the petitioner shall be entitled to simple interest of 12% per annum from 2/9/2000 till full payment hereof.
Who are the authorities now required to pay that? No affidavit filed.
No immediate file, my lord.
Oh, all have gone here. None is present. All this have gone. All of them have gone.
My lord, Narayanpur is there, my lord, in the
Where?
amended cost title, my lord.
Okay, you have amended a cost title.
Ranjana Sayapati is also there, my lord. Five and 6, my lord.
Nobody has entered appearance for the respondents.
60 was appearing, my lord, earlier.
No, Nitu, 20. Where is your amendment? When did you file your amended cost title?
But in terms of the order dated 21/8/2023, my lord. Amended cost title was filed, my lord.
Hmm. 5 and 6.
Yes, my lord.
Heard Mr. Ayat Soike, learned counsel. 5 and 6 served.
Served, my lord.
Hmm? Oh, she can take her time. We'll have the respondents personally. What is there? Contempt matter? Heard Mr. Ayat Soike, learned counsel for the petitioner. The present contempt petition has been instituted alleging violation of the order dated 6/8/2015 passed by the coordinate bench of this court in WPC number 1288 of 2014. To the extent that the direction passed therein for payment of simple interest at the rate of 12% per annum with effect from 28/9/2000 till the full payment of arrears salary has not been complied with. So it is further highlighted it is further brought on record that the state respondents had filed a review petition being review petition number 85/2018, and the same was disposed of by a coordinate bench of this by order dated 1/12/2000. However, the directions passed by the order dated judgment and order dated 6/8/2015 was not interfered with. Mr. Ayat Soike, next. Ayat Soike submits that the respondent authorities have released to the petitioner her due area salaries with various salaries with effect from 28/9/2000 to 6/9/2005, along with the cost as imposed by this court in the review petition, in the above noted review petition. However, he submits that the interest at the rate of 12% as directed by this court by the order dated judgment and order report on 4/6/8/2015 with effect from 28/9/2000 has not been released to her. When did you receive your area salaries?
Year of 2024 and 25, my lord.
So, today none has appeared for the respondents. From the records, it is seen that the director, the Office of the Director of Secondary Education Assam, by the communication dated 6/2/2026, had directed the Inspector of Schools, Kamrup District Circle, Amin Gaon, to calculate the amount receivable by the petitioner with regard to the interest component imposed by this court on the arrears salaries receivable by her with effect from 28/9/2000. So thereafter, there is no further instruction brought on record by the respondent authorities. Also, registry to issue notice to the secretary to the government of Assam, as well as to the respondent number 5, And the respondent number 6 to show cause as to why.
Sorry, ma'am.
What happened?
In this case, my lord, director has wrote a letter to the inspector of schools.
That we know. We have already know that. We already know that. What happened thereafter? We know that, madam. What is the letter dated?
Area payment of various.
It is 6/2/2006, right? Oh, it seems your direct inspector is not under your control. You have written on 6/2. He has not complied.
Sometime.
We are not like that. We know how to get our orders complied with. You may not have control over your officers. We have. We want our orders complied with. Bring the compliance report within 2 weeks, or they will come. I am drawing up contact. What? What do you want?
Personal appearance.
Personal appearance. Done. Shall I pass the order? Yes. Miss N. Fukan, learned counsel for the petitioner, has appeared for the respondents. She submits that no instructions have been given.
Well, sometime maybe a lot, my lord.
I give you time, but I want the compliance reports. When? How much time do you want? For
Definitely, I will try, my lord.
week. I'm giving you 2 weeks time.
Yeah.
Submits that she be granted time till 31/3/2026.
My lord, I will not be available, I think. My lord, first week of April, my lord.
31/3/2026. Oh, okay. On 1/4/2026 to place on record the compliance report. In the event the compliance report is not placed on record, there being a deliberate and willful violation of the directions already passed by this court apparent on the face of the records of the case, this court would be left with no other alternative but to institute contempt proceedings against the alleged contempts. 1/4.
Deeply up.
Yes.
Affidavit filed with the registrar is there, Lordship, may see paragraph 4.
Mr. Kell,
Lordship.
this much information data you had, what prevented you from sharing that to this school till now? We had to call the director. They raised that.
Lordship, on many occasions I written to the registrar, then the person who
See,
is.
this matter could have been finished off long back.
Yes, Lordship.
This is the only thing we want. Yes, Mr. Das. 2 marks out of 100.
Yes.
And
there's
you
no
have
cutoff.
now created a mountain out of a molehill.
But it says that there is no cutoff.
Does it, eh?
Only content.
A librarian, we don't want people like this. Okay, you file your affidavit in reply. In terms of the undertaking given before this court by the Register Assam University and recorded in the order dated 26/2/2026, an affidavit has been brought on record on behalf of the university authorities. Mr. Das, Learned Counsel for the petitioner submits that he be given 4 weeks time to file a reply thereto, rejoinder thereto, to file a reply thereto.
Much.
This much, Mr.
Lots. Correct, lots.
Yes.
Lordship, to review the interest part of review petition.
Yes, Mr. Interest part, what to do?
My lord, Lordship, they directly
Why it is not fractionable? And just for a deviation of 22 days, Lordship.
What is the duty of a designer here?
To design the prototypes, Lordship.
So you had another designer.
Designer from the reputed organization as per the terms and condition initially. He worked.
And why did he not continue?
So I continued up to 8th of September, Lordship.
Why after that not continue?
After that, because I was selected as the secretary and it was an ongoing.
You were selected as secretary, but the designer has got nothing to do with you.
No, I was the designer and I am selected as the secretary of the society, Lordship.
Oh, you were the designer.
Yes, Lordship. And secretary just for 22 days. And it was an ongoing process. For ongoing process, Lordship, it was not possible.
So you are agreeable to deduction of a proportionate value for 1 month.
1 month, Lordship. And prototype cost, Lordship, that is amount of 30,000 rupees.
That you are giving them.
That is also agreeable if it is deducted, Lordship.
Yes. Mr. Bachchaji, what do you have to say?
Lordship, regarding the interest.
As per terms, my lord, clause E, my lord, page 26, the organization
Page
accept
26 of?
of my review petition, my lord. The condition E, my lord, the condition accept designer, technical institution like NID, NIFT, IIT, ICT, SIDC, and state central handicaps.
Now, where are you reading?
My lord.
Clause?
E, my lord. E, page 26, top of the.
The organization accept, huh?
Yes, my lord. E, design and technical institutions like NID, NIFT, IIT, IICT, SIDC, and state public central handicap corporation, etc., to whom the design and technical development workshop project is
Anything
sanctioned,
more?
cannot engage their own member staff as designer, my lord.
So that bar is there.
That bar is there, Lordship. I have deviated, Lordship. If a that project is for the welfare of the artisan, Lordship, and there is no dispute that project has not been completed, and it was completed in front of their authorities as per the direction, Lordship. It has, Lordship. And regarding
Lordship, may kindly come to L, page 28. In the event of non-compliance of above instruction or non-completion of the project as per norms and parameters of the scheme, the organization shall have to refund the entire grant to the office of the Development Commissioner Handicraft with penal interest, which would be as per Government of India instruction issued.
Third day, Learning Council for the parties review to the verdict. This court is of the considered view upon hearing the Learning Council for the parties that the writ petition being WPC number 5347/2020 is to be first taken up for consideration, final consideration. Accordingly, registry to list this matter, a review petition along with the connected writ petition being WPC number 5347/2020 on 31/3/2020.
Obliged.
We'll finish up the writ
Yes,
petition, then come.
Obliged.
But this order has been complied with, my lord. The
Complied
petition
with.
has been reinstated.
Miss MS
SB.
SB Chaudhary, Learned Council for the petitioner submits that the directions passed by this court wide the judgment and order dated 19/9/2024 has since been complied with by the respondent authorities, and the petitioner has been reinstated in his service. So, in view of the above submissions of the Learned Council for the petition, it is found that the order passed by this court has been complied with, and there is no deliberate and willful violation of the direction so passed. Accordingly, the present contempt petition stands closed.
Obliged.
Matter will pass over. So, but they are also, his junior or Mr. Weir Junior said that.
None appears.
For the day, mother, any other day, may fix.
You are there?
Yes.
Is there? Thank you.
My lord, actually, Mr. Akepurkes will appear and he has been newly engaged. So he is not ready, my lord. Maybe any date, any other.
A prayer is made on behalf of Mr. A.K. Purkhainst for an adjournment on the ground that he was newly engaged. Requires some time. Ready matter. Prayer accepted. Registry to list this matter after. 4 weeks will do.
Yes,
6 weeks.
date may fix, my lord.
No dates. 4 weeks or 6 weeks? What would be the time required? 4 weeks?
4 weeks, my lord.
4 weeks.
And there is an bar for our provincial election, which is stopped. So that is why some agencies there on our response.
Council, you have not
Yeah,
prepared.
that is online. Offline.
Maybe people worship.
Mr. Das, both sides ready? We can take it up for final disposal. What is this additional affidavit file?
Regarding the affidavit
Five.
filed by the council, my lord, we filed, my lord, reply to that effect, my lord. So far, my lord, the issue, my lord, is concerned, my lord. It's a promotion seniority matter, my lord, between the petitioner and private respondent as to whom they are senior and my lord. And
This
that
is the same list that was there in the other case. Same one. Okay, okay. Assistant
Motion to
headmaster
the-
is school wise. Be that as it may, where is the impugned order, Mr. Murray? Huh?
Page 127. Annexer, my lord, initial impugned order may be, my lord, page annexer 17. It's that, my lord, 107, my lord. That was the recommendation of the GBC, my lord, which was under challenge at first round of litigation, my lord. I think better lordship, if I may, my lord, show the brief, my lord, background, my lord, how we have entered and how this issue has been brought up, my lord. Lordship may see the, kindly note the date of my appointment.
Your name?
I was initially
Babul
appointed.
Chandra Mujumdar.
Yes, my lord. 13 to 1992. 1990, my lord. And I joined on 2/02/1990.
Appointment?
Page.
Appointment?
Appointment date 13/02/1990. At page 70.
As
a, my lord, assistant teacher intermediate, my lord. Now
joined on?
Joined on 20 February 1990.
2 February 20.
20, my lord. After 8 days, 7 days. We'll find, my lord.
What is your qualification?
My lord, I'm a initial
time of your appointment?
PO, my lord.
PO.
Then subsequently in the year 1993, my lord, I had secured, my lord, BA.
Graduation?
Graduation, my lord, certificate was obtained on 12/01/1993. Then, my lord, lordship may see the appointment of the respondent, my lord.
Oh, when were you given the graduate scale of pay?
Yes, my lord. Then there was a notification, my lord, 30/12/1995.
Date.
30/12/1993.
You were given with effect from 30/12/1993.
Yes. My lord, that notification, I think maybe perhaps, my lord, one line may be required, my lord. Kindly see page 82, my lord.
Yes, what is there? Read.
Page 81, my lord.
Hmm.
All existing posts of assistant teacher intermediate scale pay of rupees so and so are of so and so school are upgraded to the post of assistant teacher in graduate scale of pay from the date of this order. This is the first part. Now, second part, my lord. This will be relevant, my lord. It is further emphasis that under no circumstances any non-graduate shall be upgraded on the basis of this order.
Now,
you
were upgraded with effect from 31/12/93 wide order dated?
Wide order subsequently after 1993 notification, my lord. Lordship may see the batch.
Give me the date of the order.
Date is, my lord, 22/9/1995. All existing posts of assistant teacher, my lord, those were upgraded accordingly. Page 83. 22/09/1995.
Were you actually given the benefit of the graduate scale of pay from?
Yes, I'm coming
31/12?
next immediately, my lord. Next page. Immediately I'm coming. Then, my lord, page annexure 5, my lord. Page 85.
Fixation.
Yes, scale pay was given effect, my lord. Including, my lord, serial number, my name at BR as serial number 3. Serial number 2, Ms. Sri R. Chakraborty is the present, my lord, who is holding the post of headmaster, my lord.
Okay.
By this order, 10/4/1990.
He is already in the graduate scale.
Yes.
Okay. Then what? What is your case?
Then, my lord, Lordship may see the gradation list.
Page 104.
104. That was the gradation list. My name appeared at serial number 3. And respondent appeared at serial number 4. Page 104. Lordship got it?
Yeah.
Then remarks column is there in the right hand, my lord. Upgrading to the post of graduate on 30/12/1993 wide order dated so and so.
Okay. Then
now on the basis of that, my lord, subsequently, my lord, a recommendation was made.
Why is the graduate scale in respect of the respondent number 5 shown in the seniority list to be of 26/10/94 when in the fixation order he is getting it from a date prior to that?
My lord, that fixation order is now present headmaster, not the private respondent.
Or not
I'm
the-
sorry. Yes, my lord.
Not
he,
okay.
my lord. He was now the in charge of headmaster, my lord. We are fighting for assistant headmaster. Now the recommendation, my lord. Annexure 16, page 105.
Okay, tell me why? Forget we have got your facts. Oh, what is the point? Low point.
My lord, since the rules provide, my lord, that the seniority has to be determined, my lord, from the date of drawing scale, graduate scale pay, my lord. And this honorable court, my lord, in the earlier round also, my lord, make a direction to the respondent, my lord, to decide as to whom between the petitioner and the private respondent had thrown the salary graduate scale of pay at earlier point of time. And secondly, the secretary was directed to determine which principle of law is invoked can be applied for determining so. But straight away, my lord, despite of clear-cut direction of this honorable court, my lord, they went ahead, my lord, and my lord, without applying, my lord, passing a reason order, my lord,
They
this
have passed the
impugned order has been come
127
up.
pass. Okay, take me through.
Now, Lordship, the recommendation may be required, my lord. Page 105. That was the inspector, my lord, of school, my lord, respondent
Come to
number 5.
127 directly, Mr. Murray.
Yes, my lord.
Come to 127.
127. Yes, my lord. They have just narrated the, my lord, facts, but my lord, this does not show, my lord, para 1 of 127, my lord, and para 2 is regarding so far appointment of service particulars of private respondent number 7. Then they, my lord, para 3, this
They have
regarding-
said that you, although were promoted in 93, you were adjusted sometime in 19. So you're not entitled. That's basically the projection.
that was the, my lord, accreditation of, yes.
Yes, Mr. Chudia.
Page
We'll
127.
come back to you, Mr. Murray.
Yes,
We'll come back.
page 127, my lord, paragraph 3, my lord. That is the, my lord, decision, my lord, taken by the, my lord, authority. On perusal of the written statement submitted by so and so,
Where is this order dated 15/11/2019?
15/11/2019.
And what are the rules you follow? What are the rules you are following? The 2018 rules?
My lord, at that time, my lord, school-wise seniority, my lord. School-wise seniority, my lord.
Assistant professor, headmaster,
Assistant
is still
master,
school-wise.
my lord, school-wise seniority, my
And
lord.
the other criteria are also as per the 2018.
My lord, my lord. And our notification is also there for that only 14 February 2024. And our notification provides the same procedure that is provided in the 18 rules, my lord.
Where is your that procedure?
My lord, lordship may look into, my lord, our notification that.
That notification is prior to the date of promotion of the
No,
president.
no.
Subsequent.
Later, subsequent.
So we'll
Sure.
go by the 2018 rules.
My
only.
lord, my lord.
So you mean to say that the 2018 rules is applicable here
My lord,
in toto?
not in toto, my lord.
Then what is not applicable?
My lord, regarding the, my lord, committee constituted for promotion, my lord.
That is
also,
different.
my lord.
And the criterias and
Criteria, my lord, we have adopted it from, my lord, on 2014 to 2024, my
so
lord.
those criterias are also not adopted.
My lord, at that
Not,
time, my lord.
not applicable.
At that,
So what is the concept of graduate skill then?
my lord,
From where do you get the concept
scale,
of
my lord,
graduate skill?
graduate scale and graduate post, my lord. By virtue of this order, my lord, the private respondent holding the graduate post earlier than the petitioner.
Got it.
So on that
So
basis, my lord,
from where are you determining what is graduate? Because you're not following 2018. How are you determining what is a graduate post? Who is a graduate? What is a graduate scale of pay? From
My
where are you
my
determining?
lord, the determination is based only on the only against the when the vacant post of graduate teacher is, my lord, available. That
Show me that
my lord, it is in the 120, but there is no notification like
Then-
that, my lord.
That means we will have to follow the 14 rules, 18 rules only.
My
Because
lord,
you are following that spirit.
now 18 rules we are following.
Oh, you will have to follow the NCT rules. That means
My lord,
NCT guidelines are applicable. to
my
you.
lord, my lord.
Yes, Mr. Das. What is your case?
Your lordship will kindly see page 145. 145. Council is pleased to approve the appointment of the respondent.
Oh, as Hindi teacher, 94.
Yes.
But
Then
this
my
is
lord-
intermediate.
Yes. Then your lordship will kindly page 146. Appointment order of the deponent. What I mean to say that it's a regular appointment on the basis of the.
No issue. No issue.
Then two, your lordship will kindly see.
This is also the intermediate scale.
Yes. Then your lordship will kindly see the page 148. Graduate scale with effect from 26/10/94.
So this is your case that you are drawing
I'll-
graduate
I'll-
scale from 26/10/94.
94.
So he is from 93.
But he was regularized in the year 2008.
Regularization is just an adjustment.
No,
A
no,
graduate
regular-
scale of pay is drawn
Yes.
already.
And then thereafter, what has happened, my lord? Order page 153, my lord. 2013, to the post of Hindi teacher senior, he was promoted. Deponent was
Where?
20, page 153.
150?
3. So this is the next higher post.
So how are you drawing graduate scale of pay when you are a Hindi teacher junior?
Graduate scale was provided to me.
To 94 only?
Yes.
So this is an
Graduate scale is
order earlier to that.
Page 148.
This is an order earlier to that.
No, this is 13, my lord.
This is 14.
This
So
already is-
94, sorry.
Yes.
Then how are you drawing a graduate scale when a Hindi teacher junior?
No, graduate scale was provided in the year 93, my lord.
Even if you are
94.
a Hindi teacher junior.
Graduate scale was, they will be knowing better, my lord.
Graduate
because
scale,
they need to-
Hindi teacher senior gets the graduate scale.
Yeah, but that is not an issue now here, my lord. I was told, my lord, whoever got the graduation on a particular date, my lord, they all were granted graduate scale of pay.
Okay.
Yeah, as per, there is a government notification also to that effect.
That is how he got.
He got.
But you don't get it under that.
No, I got it, my lord, because
In
of this.
94 itself.
Yeah, I also got it with effect from 26/10/94 page
94
140.
that notification was not there.
94, my lord, that notification, my lord, I will not.
Mr. Murray, where is
One,
that
two.
notification? 30/12 93.
93 notification.
So
is-
you are also
Page 82, I think. Petitioner was also in the intermediate.
but you didn't get it from 30/12/93. You got it
From
from
94.
94.
That is true, my lord. I have two submissions. and
But
I'll-
you were thereafter adjusted against the graduate post
Yes.
only in 21/12/2013.
2013, my lord, senior is a promotion order. So I was promoted in the year 2013.
Normally, this is the normal Hindi teacher junior is a undergraduate post.
Yes.
And Hindi teacher senior is a graduate.
Graduate post. So it was done in the year 2013 in respect of me, and in respect of the petitioner, it was done in the year 2019.
90.
So that is the basis whereby.
But
they
you
did
both
not-
were drawing graduate scale of pay from 1993 in terms
93,
of.
94, yes.
What is your qualification, Mr.?
Qualification, MA, B.Ed.
Where do I get that?
My lord, that your lordship will get it page para 4 of my writ petition.
Writ petition.
No,
Affidavit.
in the affidavit in opposition. ये लोग है।
Page?
Page, page, no,
Hokon Chandra Das.
yes.
Yes, where do I get that?
So do we have annexed? Paragraph 4 I have stated, my lord, but
Just show me the degree qualification. MA, B.Ed, Masters, the bachelor degree from a university, wherever, whatever it is.
132. No, we have not annexed, but we have stated in the petition.
Just show me
Para
that
4,
statement.
para 4, page 131.
It's 132.
132.
Is this the one? Middle of that, it is pertinent to mention here that
Yes.
various training
Deponent
sources such as
training
Hindi
course
Siksha
is
Praveen, training course.
Yes,
Hindi Sikshan Parangat,
yes. From the government recognizes.
master
also
degree in Hindi in the year
2014.
2000. What is this master degree from? Where from have you done it?
Page 151, I'm told.
151. Vinayaka Mission University.
Yes.
How have you done it?
Training.
It was done through your Correspondence,
No, no, I don't think so, my lord. Correspondence.
correspondence. Distance education.
Yes, my lord.
Where is your degree qualification?
Degree qualification, we have not annexed it, but if your lordship wants.
Not mentioned it also.
149 page.
Page 149.
149.
Graduation in the year 93, my lord.
From where?
From Rashtrabhasha.
So you have the qualification in Hindi from Rashtra Bhasha from this. You don't have a degree from a normal university.
Yes,
Huh?
in the year 1997.
From where?
From, I'll get it just now, my lord. If your lordship wants, I can document just.
No, no, I want your degree
Yes.
in the normal course.
Yes, first come.
From a university in the normal degree,
I was asking that only, my lord.
normal degree. Otherwise, you are not entitled. Just show me the degree qualification from a normal institution. Normal, I mean, Gauhati University, Dibrugarh University, or any university. Yeah, this Hindi degrees from Rashtra Bhasha, from that can give you a graduate scale, but that will not bring you into the graduate cadre. Now, I have not found your degree, normal degree that we know.
Graduate degree.
Graduate.
Well, that issue I have, because issue here is, well, the authority has said that I was promoted.
Let the authority say anything,
Yes.
but we'll have to be
Yes.
according to the law only.
In respect of the.
You can come to the Act, 2018 Act.
Gauhati University, Hojai College.
Gauhati University, when? Where we have not,
97.
why have you not disclosed that in the petition?
Because this was not an issue, so.
No, but
it is
still,
not.
where is that degree?
I'll
which
get
year?
it, well, if you're not, 97. This was not an issue.
So how can you be having a degree, having the graduate qualification before 97? How can you be treated to be in the graduate stream before 97?
93, well, 94.
94, it cannot be. You will have to be somewhere after 97.
Hmm.
You can come to clause 24. Rule 24.
Seniority, madam.
Hmm.
Seniority of a member in a cadre appointed by direct recruitment by promotion shall be.
Clause, sub-rule 4. Sub-rule 4. Proviso there too.
Seniority graduate classical teacher Hindi, Sanskrit, etc. having decollation from any recognized university shall be counted at par with other graduate teachers. Teachers for consideration.
Provided that the seniority of such classical teachers in the graduate post shall be counted from the date of his acquiring the degree qualification from recognized university. So you acquired that degree in the year 1997, whereas the petitioner is there from 93. So applying that 24 proviso to 4, he is senior.
My lord, your lordship will kindly take up the matter day after tomorrow, my lord. I'll take, because this is an issue, it was not in the petition.
It's
I'll
it's
take-
law. It's
No,
there in
that's
the
it, but
rule.
because they have given graduate scale of pay on the basis of something.
That
we want to
graduate
talk.
scale of pay, you are entitled because you have the in Hindi stream
Hindi
graduate degree.
Whether Hindi
But
stream is.
whether
recognized-
that will be also construed for the graduate cadre seniority is 24
But
proviso.
my lord, your lordship can see impugn order has taken into consideration.
We are not
by
concerned with the impugn orders because Karbi Anglong we have found they are, there is, but we'll apply the law here.
No, no, your lordship will apply the law. There is no, because we are for law only here.
That's it.
Huh?
If there is something more to be shown here, you can show me.
Yeah. Graduate, my learned friend says, a graduate post is 2013. Scale of pay, my lord, is different, my lord. I'll look into it.
I'll
got
show, the thing here is from the date you are entitled to a graduate scale.
I'll get to it. Because graduate in Hindi, whether it is competent to the Hindi
That you will be competent in terms of the proviso to, if you satisfy proviso to rule 4, sub-rule 4 of rule 24.
Provided the seniority of such, that one, my lord.
Hmm.
Whereas, teachers in the graduate post shall be counted from the date of his acquiring the degree qualification from recognized university. Yes, I'll come, whether that Hindi, whether it will come or not,
No,
that also.
it will not come because you will have to have a degree. Even if you see the definition of graduate there, as well as only the Parangat degree, B.Ed, it will be equal to B.Ed. Others are not.
B.Ed, yes.
Yeah.
I'll
And
look
that is the NCT guidelines also.
That is there. Next week, any date, my lord?
Yes, Mr. Murray.
Lordship has slightly pointed out, my lord, Rule 24, clause 3, 4, 5, and Rule 15, clause 3. That will cover my case, my lord. And
Heard
the
Mr.
graduate teacher, my lord, will
Murray, learned counsel for the petitioner. Also heard Mr. J. Chutia, learned standing counsel, JAC, and Mr. Learned senior counsel, Mr. Learned counsel, and Mr. B.D. Das, learned senior counsel, appearing for the response number 7. Hearing remains inconclusive. Registry to list this all khali thaka dinari. 6/4/2024. For
Pledge,
further
madam.
hearing.
can I just put it on record, my lord? Certificate, my lord?
Next date.
Advantage petitioner. Advantage petitioner.
No. Just
No, we always
say lava.
Advantage terms comes in, my lord.
Huh?
Advantage terms comes in, my lord. Because of the provision of law.
And you get your degree qualification. Wherever,
Yes,
one certificate.
I will file additional affidavit.
Oblige, my lord.
Yes, Mr. Chaudhary, Mr. Monta, what are you all waiting for? Oh, miss, you missed the bus for some better plane. Oh, that matter. And Mr. Chaudhary, your matter?
36.
Oh, we are coming there. Yes. Yes, Mr. Das.
In this case, what is happened, my lord, actually, petitioner, my lord, submitted several representation before.
Yes.
Surety, my lord. Pension.
And I don't understand why the higher education department
They
is.
have pressed, my lord, misplaced the records, my lord.
Who?
The office, my lord, this letter issued by page 77, my lord.
Oh, Mr. Das, you are here. Yes, Mr. Das, what do you say on this?
And this matter is looking after by the EU Parliament.
On the prayer of Mr. S. Das, learned counsel for the petitioner. Registry to list this matter again after 2 weeks on a date to be fixed by it.
No, date may be given, my lord.
Date may be.
Yes,
Date be-
he retired, my lord, 31/5/17.
2/4. Mr. So-and-so, learned counsel appears for the response number. He is present for the response. Yes. Mr. Mahmood, anything more?
Nothing more. Yes, my lord, it is already submitted in the forward outlines have been also given and several judgments have been also given. And division bench,
everything.
division bench order is also there of our High Court.
Yes, yes.
So those things are
Kohima
there.
bench.
Lordship, if I, during my lifetime,
Yes.
I do not get something, after death, no purpose would be served.
Family will be there. Yes.
Lordship, our affidavit will find.
Government servants benefits is not for only himself, it's also for the family. Yes.
Our affidavit, Lordship, phase number 54, paragraph number.
What is your stand? He wants regularization. What do you say? He is relying on Jaggo, Dharam Singh, and all those cases. What do you say?
Jaggo, state of Gujarat, and
Yes,
this
what do you say?
state of Nagaland.
State response is required, Lordship.
You are not responsible.
And as per the
Yes,
instruction,
Mr. Naik. Man admittedly was entitled to regularization. Persons appointed along with him, all regularized. He unfortunately was regularized by an authority not competent to regulate.
Subject to approval of the state government.
You did not give the approval. Now
State
he'll
government
be
denied.
put
State
into
government denied.
quandary. He should
Yes.
not be.
Because his appointment was in 1996. He was-
96?
Yes, he was
Where?
taking regularization in respect of a workers post to which he was appointed only in the year
Show me.
92.
92 as master role.
What is the difference between master role and
Okay, Lord.
worker?
Okay, Lordship, not praised.
That was I was.
Yes.
No.
I'm relying one judgment passed by your Lordship in Vikas Ray, Lordship. Vikas Ray, passed by your Lordship.
Oh, I made a mistake. I'll rectify it.
Then I will play,
Give me.
I will rely upon one judgment passed by the division bench in Ujjala Narjari, wherein the same counsel was the petition.
So res advocata.
Yeah.
Give me that.
Third Lordship, a one judgment passed by the Supreme Court in Uttar Haryana Bijli Vitarn Nigam. Another judgment was there passed by Justice Sanrasur Sunita Burman. Other judgment, Lordship, Nisibi Asumi.
You
Lordship,
give me
I'm
my
placing-
judgment. Give me my judgment first.
Because.
Which is that case where I passed?
Claim of family pension, Lord.
Where? Which case?
Because, name was Vikas something, Lord. Vikas Roy, Lord. The issue is settled, Lord.
I followed Upendas.
Lordship followed Sunita Burman, Supreme Court.
There is one judgment. I've been trying to find it out, but I've not been able to get it. Although contrary judgments I have got, but I've read it. That single bench is bound by the directions on the issue by the division bench. Even if there is an order of the Supreme Court, contrary to that position, I'll have to follow the division bench. If required, refer the matter thereafter. Judicial propriety. Not been able to.
One judgment is there by my Lord Justice Surana, Lordship. If you compare two judgments, one by the division bench, one by the Supreme Court, Lordship. Ultimately, he relied upon the Supreme Court.
Has he relied on a Supreme Court decision in Yakub? Yakub 1964-65. I mean, struggling to get that, but I've not got it.
So I'll try to find out.
Yes, what is my judgment?
Yes, Nathan.
Or you can do one thing, you can give me a list of those. We'll
Yes,
pass on.
Yes, we have given the
Oh,
list.
you have given, you give me a
And
list.
2025 Supreme Court judgment we have given. And-
These judgments, Lordship, only one submission, Lordship. This subsequent judgment passed by my Lord Justice Bikramnath, Lordship. All judgments were passed by him only. I have no objection. My only question is whether this judgment is to be read as something shifted from what has been settled in the.
No, you can modify your argument in this line also. That the scheme here is of 2005, right? That scheme has been gone into by the division bench of this court, saying that that cannot be extended after 2018. There is a bar operating from this court, division bench of this court in Upendas, that no
Not
further
in
regular.
Upendas, Lordship. In 2012, Lordship, even after 2005, Lordship, we are continuing with this. Jitendra is another judgment, one miscase while filing Tarini Deka, Lordship. We sought leave from the Honorable Court, allowing us to continue with the policy of regularization. Therein, division bench said no.
But the Learned Council for the parties.
Our High Court also given the
Restrict
right.
list this matter again. 6/4/2026 for delivery of orders. I'm not decided. Let me see which side we'll go.
This is very serious. If implement would be there.
Let the interfere, sorry to, in the course of your lordship's argument, because hearing matters are going on now, I'm told.
I will finish off now.
My matter is 6. And I'm afraid whether the learned state council will turn up. Because till now,
very
face
bad.
was not seen. At least once, no face was seen. And that,
Mr. K.K. Mahanta, Learned Senior Counsel, is present. However, there is none to place the matter on behalf of the respondent.
Mr. Senior Advocate is there,
respondent,
government advocate.
the respondent in the Department of Higher Education. In the first round, when the matter was called, it was submitted that the arguing counsel is on legs in another court. However, for the whole day, none had appeared for the Higher Education Department. Also, in view of the above position, registry to list this matter again on
It can be day after tomorrow morning.
this week, not possible.
Can it be 20 or 24, my lord?
Why you're not interested to do this matter? This is the second day today. Whole day you made the senior counsel wait. Have some gutsy. Tell him that
Yes,
we are having
10:45,
difficulty.
right from 10:45
I don't like it.
I'm here.
Senior counsels coming and sitting in the court the whole day, expecting the responding counsel to come.
Unacceptable. This is a
This
new
is not
trend
done.
coming up.
This is not.
I'm really very sorry to say, I'm to say so many.
I have said what you want to say, Mr. Mathur.
No, but Mr. Gogoi is in the other, I have seen.
The same thing happened last day.
That's
So do one thing. You give me a convenient date and a time. We'll record that in the order. We'll do that. Give me a convenient date and a time. We will record it.
I spoke to Mr. Gogoi, my lord. He said 20 or 24 will be convenient.
On 20,
may not be on 20, but I am for the response number 7.
24.
But that lordship may take it out 18. Not barring 20, 23, 24, my lord.
25?
25.
25. 2026 at 2 p.m. At 2 p.m.
Lordship will decide it this way, that way, even if I may not be able to
We
appear.
only want to hear it. That's all.
Yes, my lord, I
I
have
will
already
respond
pressed
on
my
the
case. Let their convenience be
Just
there.
write down the names of all.
Yes,
Legally.
lordship, lordship.
So that their convenience is more important now,
2
not
p.m.
my convenience.
2 p.m. Yes, 36.
Leave you.
25.
May please, your lordship. The petitioner was working as in the of a high school, your lordship. He was relieved from his service by impugn order dated 20. By impugn order, he was relieved from his service, your lordship. That was passed without properly due procedure of law.
Mr. Chaudhary, you are appearing for?
The respondent, private respondent. Respondent number 4.
Impugn order, kindly see your lordship. Page number 40, your lordship. Just passed, your lordship, without fully.
Only this much. What is the error?
Hello?
In page 40 order, what is the error?
My lord,
Any department person
the
instituted?
process of law, your lordship, I
Why?
was relieved from service.
With such serious charges, you have not instituted any department person.
The matter has been referred to the local department for this
That means till date, you don't have any concrete material against the petitioner.
122.
And would be audited, your lordship.
Page? Page? Order dated? Order dated 28/5/2024.
Page 40.
40, that's it. Yes.
And to be audited by local audit department for taking RLFTA.
You have not even placed him under suspension. Not there. Mr. Chaudhary would have known. Not there. So if this is the serious allegation and you have let him work in this capacity for the last 2 years nearly, fine. The mere checking of a charge will not do because the allegations are serious. That shows that it was only you have just to prevent him, you have done this. What is the answer to that? Why should you have to take? Will they give you an instruction saying that they have done it only to prevent him from functioning? Yes, madam.
It is stigmatic, your lordship. If you order is stigmatic, it will suffer my future service career, your lordship.
This post has not been put up for regular recruitment now? No. Yes, Mr. Chaudhary, what is your?
Milord, matter is very simple, Milord. Please take my affidavit.
Hmm.
His substantive post is assistant teacher. And his condition of service qua the post of assistant teacher has not been affected in any manner. Now, Milord, there was a complaint. Please come to page 87.
Of your
There was a show cause, yes. Whereas you have taken money of rupees so and so as reported, which is a crime, being a government employee, and whereas Anamika Singh stated that some undesirable incident situation has taken place during your presence in the school, but you did not pay any heed, etc., etc. Then please come to the last two subpara. In spite of a repeated request about above mentioned incident, you did not pay any attention to resolve the problem till date. Under the above circumstances, you were asked to show cause as to why disciplinary action shall not be initiated against you.
This is an explanation.
Yes. Then, my lord, there was apparently a hearing where the petitioner participated that your lordships will get at page 104. With reference to the subject cited above, I am directed to request you kindly to attend in the hearing to be held on so and so in the office chamber of the undersigned with all the relevant records regarding the matter related to allegation against Mohammed Anwar Hussain, headmaster. After this, my lord, proceedings they will be having. Thereafter, the impugn order at page 47 was passed. Now, my lord, the issue is he was holding an charge. Now, his substantive post is assistant teacher. Now, he has been relieved. Now, I don't think it calls for an action under 311, my lord, because only when, my lord, he would be punished, my lord, then only that question would come. Now, enough notice has been given to him. He appeared in a hearing, and thereafter, my lord, he was relieved from the temporary charge he was holding. Now, please come to page number, my lord, 111, my lord. Order by which he has been relieved, my lord. Read the report received from Inspector of School Nagaon on the allegation raised against Anwar Hussain, assistant teacher headmaster, comes so and so. Also read the report of the hearing conducted by Deputy Director where it is opined that teaching, learning activities and the working environment of the school.
Sorry,
has been-
Mr. Chaudhary, where are you reading?
Page 111.
It's a part of your affidavit?
Yes. And this was passed by the director, Miller.
Some problem with the
28/5/24. Same order, Lordship finds at page number 47, na?
Only 47.
40, Miller. Same order.
That is that relieving order?
Yes.
No,
So,
we have got it.
so she was given an in charge. Now, my lord, financial power is being exercised by the inspector of school.
No, I'm not on that. I'm not on that.
No, and my lord, the client, our client, he is doing
Academic,
the.
that is,
Ah.
I have already held yesterday.
Yes,
day
lordship
before
is
yesterday.
correct. That way, actually, it's a case where it calls for a DP.
No.
Even his substantive appointment should be done away with.
But what I'm on is
Hmm.
academic in charge. I have held, I think, day before yesterday, that this is nothing, no benefit is accrued. If the government official is holding the post, it is up to his discretion to appoint somebody to look after the academic affairs.
Yes.
So that is nothing. Now, with this serious allegation, Mr. Chaudhary, my question is that if the person is continued in the school without any action,
It's
can,
sending a.
can a view not be taken that this was just a smoke screen created to remove him?
Had it been an allegation in the air, now merely because the authority has not taken in stringent action, the allegation do not evaporate, my lord. I think she should her clients should thank her
lucky.
star that they have not taken a disciplinary proceeding. But to say, my lord, that here is a case where 311 would be attracted, I don't think, my lord, that's permissible. She was holding an in-house position.
Has not been given.
There are
given
some.
to the- Given to the IS only.
Yes. So, my lord, now the matter is very simple, my lord. Financial matter is looked after by and academic matters are being looked
Yes,
after.
I just want to know what steps you have taken after 28/5/2024. We have got your point, mister. But I want to
think,
know why
I think I'm only holding the, my lord, academic charge.
that if we don't interfere with this, we are not interfering.
Yes.
Even if we,
But even on the petitioner's allegation that this order is stigmatic, my lord, I think it will be stretching too much. Yes, if her condition or his condition of
Service was
service
changed.
as an assistant teacher is changed because of this impugn action, I think the authorities have dealt with the matter leniently. Rather, a regular DPC should have
Rather
been
too
instituted,
lenient. Rather
and he
too
should be
lenient.
placed under suspension. We have
No, no.
to click on it.
this thing should not be permitted. Heard the Lana Council for the parties at some length. So, what naam le lo bote? Mr. P.P. Dr. Lana Standing Council, Secondary Education Department on the next date of listing shall apprise this court as to the further steps taken in the matter by the respondent authorities against the petitioner in pursuance to the issuance of the order dated 28/5/2024 with regard to the allegations noticed in the said order existing against the petitioner. Let us see what comes, Mr. Chaudhary. We will not trouble if something comes up, your junior will call you. Otherwise, we'll pass the orders.
Deeply.
Raise it to list this matter again. Aba khali date diya. 6-4. Yes.
I apologize, Lossi. One matter was going on, Lossi.
You, something happens like that, a senior counsel waits, kindly inform him that this is the issue.
Lossi, morning onwards matter was going on, Lossi.
Ask
Morning
your
onwards,
colleague,
morning
inform.
onwards, Lossi.
Just ask.
No, even his senior junior, I have informed, Lossi. Mr. Montosar junior, I have informed at 1 PM, Lossi.
You inform.
I am informed.
That was not communicated.
I informed, Lossi. I informed.
Yes, what is here, Mr.
May I pray, my lord, to take up this on Thursday, my lord?
Iftari.
My lord, after 20, my lord.
On 24th, Lossi. 24th, I have no difficulties.
No dates.
Lossi.
It will come. 2015. madam. Yes.
Yes, my lord, can.
On the
please-
prayer of the Islamic Council from the parties, registry to list this matter again after 2 weeks on a date.
Even also before 1 PM, I have informed the council.
Mr. Gogoi, that was not
Before 1
transferred.
PM.
That data did not come.
Lossi,
Yes.
Lossi.
Yes.
May I please, your lordship? Lordship, my senior is in court number 9 and
Can't
the
help it.
matter, hearing matter is going on,
Fine.
lordship.
We had heard the matter half, then it was dropped. So can't help it.
After some time, lordship.
Who is going to wait for you? We are dismissing the writ petition.
Sometime may be given, lordship. Because, lordship, I am not aware the facts of this case, lordship.
Okay, till I finish those items. Yeah.
Deeply aware.
On the prayer of the Learned Council, Mr. Learned, registry to list this matter again after 3 weeks. The matter be not treated as parted and tied up matter with this court any further. Right. Yes, where is Mr. Soikia? Yes, Mr. Soikia.
In the earlier case, my lord, the affidavit filed by the headmaster of the school, that is completely different story has been projected.
Not only the headmaster, even your affidavit.
My affidavit also, my lord, said that.
That is why I
he
told you.
joined,
You will be shocked.
my lord.
I thought I should not be passing this order without disclosing to you. I went through it. I was shocked myself. That
Yes,
such diametrically opposite stands have been taken. And I thought I should bring it to your notice. That much of it.
But, my lord, regarding the manipulation of records. and all,
That we
my
will
lord,
not go because that is not there in the earlier round of litigation.
my lord, the criminal case, they have lodged a complaint case
Be that as it may.
that has been
But
closed.
see, this complaint case, this thing, are only to show that something had happened. You get my point?
As I have been informed that, my lord, the headmaster, my lord, in connivance with the private respondent herein, my lord, has created all the stories. But
Maybe.
my lord, one thing, my lord, I found, my lord, awkward, my lord. I'll stand taken in the earlier writ petition as
Is
well as
not the
the,
one.
the writ petition is not same. by the
And
petitioner.
here, see, there is 2 points. Here, the case is that he was terminated.
Yes, my lord.
That implies that he was appointed.
Yes, my lord.
You get my point? And you also admit that he was appointed on so and so day.
My lord.
But additional post.
Yes.
Be that as it. In the earlier round of litigation, completely diametrically opposite,
Yes,
it
yes.
says he was never appointed.
Yes, the resolution was taken, but
So
no
what
appointment
should
was
this
issued.
put-
But, my lord, one thing.
What
my
is
lord,
your client doing?
my lord, he is not doing anything now, my lord. He is a
You
handicapped,
can't even pass
And-
some
and-
very heavy amount on him also.
my lord, he is a handicapped person, my lord. I am also doing it for free, my lord.
So we will also
Saying-
dismiss it for free. Anything more, Mr. Soikia?
My lord, the private respondent here in, my lord, his name did not find place in the price data.
Because that is also taken care of in the earlier round of litigation, because that was not put up by the headmaster at that point of time.
So, my lord, headmaster had intentionally did that, my lord. And one more aspect, my lord.
That we will not
in
go
the
into.
inspection report, in the inspection report also,
Your name is there.
he was not there.
Your name is there.
My name is there,
But
but his
earlier
name
round
is
of
not there.
litigation, these aspects were not brought on record.
Yes, ma'am. Yes, ma'am. That is true.
So now the allegation of the respondent of 5 that there is manipulation along with that LDA of IS office gets fortified.
Maybe manipulation may be done by the private respondent also.
Who did it? Who did not? Why should we go into this dispute? But if there was a similarity of stance, then you had a very good case. We could have done something. Finish it off.
My lord.
But Mr. No cost. But Mr. Ayat Soikia, Lana counsel for the petitioner, also heard Mr. B. Talukdar. Yes, Mr. Talukdar, anything to say?
My lord, my commissioner, speaking on the person, my lord, on the basis of order passed by this honorable court, my lord, and page 31, my lord, and passed on in the year 2015, my lord. Subsequently, he, my lord, annexation 9, my lord, the petitioner filed one representation before the rector in 2021, setting allegation against it. So,
What about the termination of the services of the respondent?
That was, my lord, in earlier session, my lord, in Kansas State, my lord, the termination done by the managing committee, my lord.
That is not applicable.
My lord,
That is not applicable.
in Kansas School, my lord,
You are the standing counsel. Education, whatever you say, we'll have to accept. Now you tell me that that termination is of no consequence.
and he challenged the, my lord, 2011 Act, which is ultraviolate by this under provincialization under 2011. is under.
So you will consider him under the 2017 Act?
No, my lord, that earlier, my lord, in 2015, my lord, we have provincialized the advertisement.
Why was this case rejected?
That was, my lord, in 31 page, my lord, speaking order
What is the ground?
on the ground that, my lord, last paragraph, my lord, the petitioner and along other manipulated the, my lord, their document, my lord.
Who made that allegation?
My lord,
Who made that allegation? What is the proof of that manipulation?
may I read, my lord,
I just want your submission on that.
it issuing appointment order of the dwelling, it seems that appointment letter issued by the secretary of the Pondia Solomare LP school is manipulated one, my lord. Headmaster, my lord,
Any police case, any report?
no.
Then you are a forensic expert. Education department is a forensic expert. Authority.
And
Yes, what do you have to say?
Page 31. Speaking order has been passed. In the.
We all know that page 31
On
is
the
a
basis-
speaking order, but
On
what
the
is
basis of record, your lordship.
Huh?
On the basis of record and after hearing the.
Mr. Soikia disputes those records.
My lord, the termination suffered alleged by my lord, and that is not on record, your lordship. That is.
Whose termination?
The petitioner has alleged that the respondent, private respondent 5 was terminated in the year 2004, your lordship. The same is not on record.
Where?
That
It's
is
there on record.
That is manipulated one.
Manipulated. Who manipulated? Who manipulated the signatures of all the people, villagers?
And my lord.
What is the proof of that it was manipulated?
In the earlier round of litigation, your lordship, they taken a stand that I was never appointed. But here in this litigation, your lordship, they are admitting that I was appointed, but new fact have been brought regarding the termination.
They took that stand in the earlier round of litigation because you were terminated. That means you are not appointed. So you are not entitled. That is why Mr. Soikia took that plea. Today, she said, no, you are appointed, but you were terminated. But the learned counsel for the parties at some length. At some length. Hearing remains inconclusive. Registry to list this matter again on date Radia. 7/4/2026. We'll pass the order on that day.
Regarding termination resolution, my lord, I have stated in paragraph 5.
Oh,
They have not denied that, my lord.
I just wanted to have their perspective. That's fine.
There is no only reading. There is no notice, no termination order from the SMC.
In the
They have
school,
shown only
Mr. Counsel, in the Namgita likhi lo bode. In the venture school, notice is required, which is the law. 2094, which is the law operating. 2004, which is the law operating.
resolution may be false one, my lord.
May be false. It may be true also.
And after 8 years.
Always prepare your brief and don't make submissions where a submission is not called for. Remember that.
Sorry.
Don't make a submission where a submission is not called for. Yes. And always see the court's mind. Court is interacting with Mr. Soikia. Court had expressed this mind. Getting a response, Mr. Soikia. What is there further to argue from your part?
Sorry.
May I please, your lordship? On the last occasion, your lordship, the hearing has remained inconclusive, your lordship. Your lordship, those are my humble submissions, your lordship. May I be allowed to submit the written arguments
No.
which I have prepared, your lordship?
We are closing it.
I just raised the judgment, your lordship, of Rajasthan.
Rajasthan case.
Surjit Devi.
This is the one, na?
Yes, your lordship.
Your lordship, one may judgment also be taken into consideration, your lordship, Kulwant Singh. Gill, your lordship, which has clarified your lordship. And those were the earlier two judgments where I had.
There was
also read.
another judgment which fell from your lordship when your lordship was sitting in Itanagar bench. Along with Justice, Honorable Justice Kadak Ate. There also your lordship relied on this judgment.
That this decision. What is that decision? Some police.
Yes, yes, yes.
Huh?
After a long span.
Police.
13,
I think it's
14
land, something with regard to land.
Yes. So even if your lordship held that even if illegal, there might be some illegality, but
we'll-
delay in.
Can you just give me that side?
Yes, I'll just.
Your lordship may
Email.
kindly consider this judgment as well. Kulwant Singh
Please,
Gill.
please.
Only three judgments which I have relied, your lordship. In this written submissions also, I have relied only those three judgments, your lordship. May I be allowed to submit the written arguments as well? Continuing wrong. He should.
No.
Para 4, your lordship, of Kulwant Singh. Even if there's a penalty, is a major penalty, but that cumulative effect is your
I'm
lordship.
sorry, that is not the ratio of this judgment subject to correction. It is that even if this penalty is imposed,
Yes,
you
your
will have to hold a regular inquiry.
Oh, yes, your lordship. But the effect of cumulative effect has been described with your lordship.
There may be a wrong thing, but it has happened.
It perpetuates the wrong, your lordship.
It has happened.
Your lordship may record my submissions.
Actually, I'll have to.
Yes, your
Do
lordship.
you fear? If you want, you can dictate the order.
No, your
Basically,
lordship.
you want.
I apologize, your lordship. Much obliged, your lordship.
Ukurubare Didia. The 11 Council Party parties at some link. Hearing remains in control. Register to list this man. I'll pass the order on 30.
Yes, I'll just.
Just give me that. Give it to us.
Much obliged, your lordship.
There's one more decision of Rajasthan, from Rajasthan Supreme Court.
Pappu. There was this judgment which I came across, your lordship. Pappu, somehow Pappu stuck with me. So I could just because that particular judgment, your lordship, relied upon 6 months back, your lordship, with regards to a constable of the Assam Police. And I only appeared in that matter, and that case also, your lordship, I cited that particular judgment. Of course, as my learned friend has stated, he filed representation, and C. Jacob also is there.
Yes, your lordship.
Representation will not.
Yes, your lordship.
I told him.
Yes, your lordship. I agree.
Anyway, he's trying. Let him try.
Yes.
Much obliged, your lordship.
Mr. Neka, if you get something more,
No, your
feel
lordship,
free
that
to
issue.
no, feel free to come up on the next day and tell me point blank. I'm here.
That issue has already been decided by the Allahabad High Court, what your lordship has just put up, your lordship. That
What?
this stoppage of cumulative effect.
That is different.
Yes, your
That is
that is settled, your lordship. So yes, your lordship. That has also been taken consideration.
Yes.
Much obliged, your lordship.
Iman? Yes.
The page 111, Lord,
Of
of the 2017 Act. This manual, Lordship.
2017 Act.
Yes, Lordship. 312. 312, page 111.
312.
Bottom, Lordship, the enrollment shall be verified with the data as per DIAS 910 or before, as available in the records of the National University of Educational Planning and Administration. There shall be, this is important, there shall be physical verification of students and checking of records of attendance of students of last 3 years.
You make a dispute, if you have raised a dispute with regard to that, we would have asked them. You have not raised, you have accepted. You have not even argued in that line. Not even content.
Council is there, that is why let's earlier I submitted for the fault of the council, the petitioners.
We are not
Lordship,
here.
you remand the matter, let them take a decision, Lordship, because I don't have any.
You withdraw this, go before the tribunal. Take your chance.
It is already there.
Huh?
It is already there in.
No.
In division bench order, that is there.
It's there.
Yeah.
Show me.
Yes. First kindly see
Hmm.
page 134. This is the single bench order that was upheld. Page 134. Kindly say after two lines. If such an application is made by the petitioner, the same shall be considered on its own merit and in accordance with the provisions of the Assam Education Promotion of Services of Teachers and the Organization of Education Institute 2017.
That
And
repetition
that was
filed.
upheld by the division bench.
Repetition is on filed and decision is taken.
No, that we are not saying. If you dispute this position, go before the
And
tribunal, withdraw this, we'll give you liberty. Go
and
before the-
division bench order 142. 142, para 16.
142.
Para 16.
Huh.
However, it is reiterated that the case of the appellant may be considered for provincialization under the 2017 Act if an application is filed as indicated by the learned single judge.
But the act came into force to April 2017. They also have considered for 14, 15, 16. And there is a document, Lordship, for a moment, kindly see page 43. More than 173 students. Page 100, because this is the application for which.
How many students are there?
173.
Show me.
Page 43.
Hmm.
For 2007, 120, total Lordship, kindly see, enrollment of students. For 2012, it is 173.
Oh, that will not come here. This act is of 2017.
14, 15, 16. So immediately after 2 years.
Okay, show me your statement to that, corresponding statement to that.
Nothing is there, Lordship. The set of council is different. That is why I am repeatedly.
Then I've examined that. It's not there.
Also, by in view of Lordship, with 312, Lordship.
312, you will have to give me a handle. That 67 and 87.
Only the order says 16 and 17. Sorry, 17 and 18. But they
no, 2 years.
Only 2 years, and that too also for 17 and 18. Let's say for a moment.
Where is that requirement for 3 years?
Yeah, they are last 3 years.
Yeah.
Yes, for last 3 years. 111, page 111.
Twelve.
Yes. Yes. Now, there shall be physical verification of students and checking of records of attendance of students of last 3 years. The act came into on April 2017.
Okay.
16, 15.
So highest number that will go is 173.
73. Now this is in view of
173.
RT
Act will come in. 100 means one principal.
Above 80.
100 will be one principal. Above 80 will be one.
Yes.
So 160 will give you 2.
No, more than that. Because Lordship RT Act. Lordship take up this method next to today. Lordship, I am also not. RT Act. In this Act, Lordship, there is no RT Act.
There is one.
In RT Act, section 25 specifically provided. Because 312 also there is a additional provision for appointment of additional teacher. It will depend upon the ratio as laid down under the RT Act of 2009. But in this manual, Lordship, the RT Act is not available.
RT or compulsory education.
Why should we go into venture into
Yes,
those things when you have not even pleaded those things?
Admittedly, Lordship, the director has not.
I can give you an
considered-
option. I can give you an option if you want to withdraw and approach the tribunal for establishing your right under the.
That will not serve my purpose because already there is an order and findings of the appellate authority, Lordship.
Challenge that. You establish that in the tribunal that the school had so many numbers of teachers. So students enrollment was this.
Let me have the instruction, Lordship.
No
Because
instruction today or not. Or we'll listen.
Because I am appearing on behalf
Okay,
of Mr.
heard
T.K. Priya,
Mr.
Lordship.
A. Deka, learned counsel for the petitioner. Also heard Mr. M.U. Mahmood, learned counsel, appearing for the.
Respondent number 8.
And Mr. P. N. Sharma, learned standing counsel, elementary education department, appearing for the state respondent.
Right information from RT Act.
Hearing concluded, raised it to list this matter again. 7 for delivery. We are dismissing it.
Right.
Today it's 4:30. I don't want to do it.
Obliged.
You are in Roja.
Lordship.
Registry to list, as agreed to by the London Council for the parties, registry to list this matter again after 2 weeks on a date to be fixed.
Okay.
But we should not be putting him in more trouble.